Yes. But it is registered as CRP. But revision, the usual revision will not lie against the order. 115 will not lie. Have you examined? You give the particulars to our court master, we'll examine, then we'll not pass any orders. We'll talk to the registry, what is the problem? Okay. No, just the details of the case. When did you file? We'll not list it immediately. We'll have a talk with the registry. Okay. Give the details. Madam, give the details to our court master. You can have the mention memo itself. We'll have the details. Okay. Mhm. Against you have come against what? Correct. Okay. Hmm. Yes. Okay. Okay, have it on Friday. We'll examine that this aspect. Okay. Yes. Twenty-two. Yes. Need to hear it to comic only. Kindly switch on the microphone. Yes.
Item 22, Lord.
22 years.
We take for adjournment.
You
Upon
have-
defendant.
Okay. Inform the other side.
Yes, my.
Yes. On a prayer.
So, Madam, ticket 21, Amar.
A prayer for adjournment has been made on behalf of the respondent, opposite party. First of para. Since urgency has been expressed on behalf of the applicant, comma, list, while this matter is adjourned, comma, it is directed to be listed on 21st of next Friday. Will be difficult, but still 21st of, okay,
Oblige.
21/6.
First, I beg to mention one item for listing CRP IO press matter on Friday.
Hey, please, I beg to mention item number 30, we have filed an additional affidavit that's not tax exempt.
Bring it.
Made physical. Lastly, I was seeking your permission for listing of a hearing matter, my lord, matrimonial estate. On
Hearing,
Thursday-
it will not come up for hearing, it will come for orders.
It's, my lord, it has already been, matrimonial appeal already been heard, my lord. Earlier it was division bench, my lord, but because of that
Then
notification.
you have to file an application before the registry. By making a mention memo, you cannot fix it for hearing. It'll come for orders, we'll have it for hearing. You file an application or you have it on any other day, we'll pass an order to list it for
Next
hearing.
Thursday, my lord, if possible. Thursday,
It'll not directly come for hearing,
orders, my lord.
orders.
Then, my lord, on 19th, my lord. Next
Okay,
week, 19th.
19th,
Nine.
19th for orders, yes.
May I please, Lord? With the consent of the appellant, I beg to mention item number 25. Here they have filed applications for substitution with a delay of more than 1,300. Want to file an objection.
You want to file?
Yes.
You have informed the other
Yes,
side.
Babu.
On the prayer of Sri A. Barua,
Yes.
learned counsel for the
Yes.
opposite party respondent, matter is adjourned by 3 weeks to enable filing of objection to the petition for condonation of delay. Okay. 3 weeks,
Problem.
Koloniki. 3 weeks.
Obliged.
Yes.
May it please the Lordship. Lordship, I beg to mention item number 17. Lordship, the item may be taken up after the ensuing
After
summer vacation
22 matter, year for whom?
for the petitioner's office. Item 17.
Other side informed
Yes. You've taken the consent.
on a prayer made on behalf of the applicant. The IA is for what? I-22 matter condemnation. The RSC is yet to be admitted. Why are you seeking time?
Happiness.
No, are you seeking time? How many days delay? You check the records. We may condone the delay. If we have other intention, then we'll adjourn it. Otherwise, why do you adjourn matters like this? You go through the court file. Not now. And inform the other side. We'll take up this matter.
May it be please your Lordship. Lordship, I beg to mention for listing one MFA matter. It's a very old pending matter, my lord. It's the year of 2013. And as per the last order, this matter has been excessively heard by you, Lordship. Lordship, matter may be fixed on tomorrow.
MFA. What is the matter about?
Lordship, it's a injury case, my lord. Railway Claims Tribunal. And party has been suffering, my lord, since 2013.
Extensively heard. We don't remember. Is it the Parthad matter?
But no, my lord, Lordship, in this last order of 22/8/2023, it has been submitted that in the court number 10, the appeal has been excessively heard. Therefore, the matter shall be listed before the appropriate time.
1 year matter. How can you make a submission extensively heard? Are we to remember a matter of 1 year? Since we are having this bench, we'll have it, but not tomorrow. Tomorrow we are already full. We'll have it on Tuesday next.
Right. Lordship, I may be allowed to.
F. Intaz.
Lord.
Miss F. Intaz, learned counsel for the petitioner, submits that there are instructions to withdraw this petition. First up, Miss, any government advocate? Yes.
6, 7, and 8.
T.R. Gogoi,
Lord.
learned government counsel, and Miss R. Chaudhary, learned counsel for the respond numbers 2, 3, and 4 are present and do not object to the said prayer. Full stop para. Petition is accordingly dismissed on withdrawal.
Obliged.
Yes, Mr. Lord. My lord, this is a transfer petition, my lord,
Yes.
filed under section 24 of CPC. My lord, the wife is before your lordship, praying for, my lord, the transfer of a, my lord, case, my lord, which has been filed before the principal judge, Kamrup, my lord, Guwahati,
Case under what?
under a restitution of conjugal rights.
Husband has filed.
Husband has filed. Now, my lord, prior to that, your lordship will find, my lord. I have
Restitution
next-
petition instituted where?
My lord, it was instituted in the family court, Guwahati, by husband. It is filed, my lord, in the year 2023. But my lord, your lordship, my lord, what has happened, the marriage took place, my lord, in the year 2019. Soon after marriage, my lord, the petitioner, my lord, wife has been subjected to cruelty, my lord. On
Where was the marriage?
My lord,
Where was the marriage?
my lord, marriage taken place in Bongaigaon. Now she is residing in Bongaigaon at her paternal house. My lord, she filed a divorce petition my lord, before the learned district judge Bongaigaon, my lord, under section 27, my lord, of the Special Marriage Act, my lord, because which is pending before the learned district
The
judge.
marriage was under the Special Marriage Act,
It was under special.
not
marriage.
under the Hindu Marriage Act.
It was solemnized, my lord. It was solemnized socially, but thereafter, my lord, it was.
You have not
marriage was
filed,
registered.
you have not filed Section 13 application.
Because, my lord, marriage was registered under.
Now that registration will go.
Yes,
What about the Hindu marriage?
my lord, the social marriage has been solemnized.
What will happen to that?
My lord, that will my lord, because subsequently, my lord, marriage has been registered, my lord.
That will not do.
My lord, that is
That will
why.
not do.
That is why. That is
Okay,
why,
that's a different matter.
my lord. My lord, we filed, my lord, a petition for divorce. It is a fact, my lord. In the year 2021, he is contesting the suit, my lord, at page, my lord, annexure 6, page 33. Then, my lord, we have also filed a petition for maintenance, which is pending before the learned CTM, Bongaigaon, my lord. In that case also, the husband is appearing contesting the suit. Both the cases are fixed for PW. Now it is almost at the fake end of track. My lord, in that particular cases, he
What
has.
is the stage of this restitution petition?
Stage, my lord, we have filed written statement, just. My lord, written statement, but now, my lord, it is very difficult for her to come all the way from, my lord, the Bongaigaon to Guwahati, because in the family court, my lord, party has to present. But in the district court, my lord, advocate can present on behalf of the party. Now here, my lord, each and every case,
Bongaigaon, you have a family court,
no, district judge.
district judge.
Yes. So,
Okay.
my lord, he is appearing
You have
here.
any issues?
My lord,
Any issues?
no, my not. My lord, it is very.
What are your grounds?
My lord, ground we have stated, my lord, that, my lord, I have to appear, my lord, all the way from
That
here.
is, that you have already stated.
My lord, and my lord, she is now dependent on the family, on her parents, my lord. Parents has been.
What, the petitioner, she does anything?
No, my. She is dependent on her parents. My lord, parents now, my lord, retired. Her father retired, my lord, from service. He is getting pension, my lord. And
Petitioner is not working
no, my
anywhere.
lord, no, my lord. She is not working anywhere. Now, my lord, she has no independent income. Therefore, my lord, it is not possible for her.
When is the next date?
My lord,
When is the next date?
my lord, next date is today is fixed for next date. My lord, today is fixed here in the family court. But in the Bongaigaon court, my lord, yes, there are some.
No,
And
Bongaigaon, we are not concerned. Guwahati case to fix
It is
today.
today for filing, my lord, assets and liabilities of both the parties. Now, my lord, it is very difficult, my lord, for her because she has to come, my lord, a day before the date fixed. She has to stay in the hotel along with her parents. my lord.
What is the distance between Bongaigaon and
My lord,
Guwahati?
it takes, my lord, if he comes in the early in the morning, my lord, she will not reach at 10:30, my lord. That is the difficult.
By the train?
My lord,
By the train?
by
Morning
the
train?
train, my lord, by the train I am saying, my lord. It is not possible, my
What
lord.
time does it reach Guwahati?
My lord, sometimes she reaches at 12:30 like
12.
that. My lord, my lord, at 10:30 she may not reach me. That is the difficulty. Number one. Number two, my lord, she has no independent income. And she cannot afford, my lord, that much money, my lord, to come, my lord, all the way from each and every day to participate in the proceeding, my lord. And moreover, my lord, he is the
You have
husband, my lord.
instituted 2 proceedings, engaging counsel. You have money to engage counsel. You
Well,
don't have money to come to Guwahati.
There, my lord. There, my lord. There, my lord, I have instituted 2 cases. Yes, my lord.
By engaging counsels,
By engaging councils, my lord, the councils, they are, my lord, benevolent in, with all respect, my,
we do not know.
that is my instruction, my lord. They are working benevolent, and one of the council, my lord, related to them, my lord. That is why, my lord.
Even
my
here,
lord, that is of the
even
record.
here you will have counsel who will be related. In fact, you don't need a counsel here. It's a family court.
That's true.
The expenses are zero.
But I'll have to appear, my lord.
Zero
each and every
expense.
day, each and every day.
If you come by train, you don't pay the fare also.
No.
We
Wha-
know what is going on from Bongaigaon to Guwahati. Nobody pays fare. Hardly 10%.
No, my lord, she has to come along with her parents. She cannot come alone, my lord.
What is your
She is
age?
My lord, I am 34.
Huh?
34, my lord.
What is your qualification?
My lord, I am a graduate, BA graduate.
You cannot travel alone from Bongaigaon to Guwahati.
I can, my lord, but
You are
I have
34,
some
you are a
gynecological-
graduate, you are depending on your parents.
I have some gynecological problem. That's why they do not leave me alone, my lord. They accompany us.
You don't travel anywhere.
I am not, my lord, now. Now, my
Anywhere.
lord, now, my lord, I don't go alone anywhere. My parents.
How old are your parents?
They are, my lord, 65 years, father, and mother 60 years. Like they accompany her each and every day. They have to come here and, my lord, stay in the hotel.
And in the court, that two proceedings, the parents accompany you
Yes, ma'am.
every day.
Yes, ma'am.
Both the parents.
Yes, ma'am.
34-year-old. You have not grown up.
I have grown, my lord. I have grown, but physically there is some health issue, my lord. That's why, my lord, fire.
Was it a child marriage? Not a child marriage.
No, my lord, no.
No, you said that
Absolutely
you
not.
you are not mature, you cannot travel,
Yes, my lord.
you are a
I
graduate.
can, my lord, but problem is, my lord, I cannot afford the, my lord, each and every day, my lord, the traveling allowances. My lord, then I have to
We'll have
stay,
this, we'll have VC for you.
my lord.
You'll have video conferencing for you. You don't need to travel.
From there only.
Yes.
That, my lord, I'll have to take instruction. My lord, the 30
Take
minutes,
instructions.
my lord.
Today was already a date, no point in staying the proceedings. Today something has already happened. What has happened today?
My lord, today we have filed an application for taking adjournment. Because
Who has
today,
filed?
my lord, the wife has filed.
She has come.
She has not come.
Then who has filed?
We have filed, my lord, on behalf of them.
That is it.
Stating that we
So
have.
you are not
instructed-
required, your physical presence is not required on each and every date.
No, physical presence is required in family court, my lord, because parties are there.
No, you
But
said
to-
today in family court the
sometimes,
matter
my
was
lord,
there.
Sometimes, my lord, if parties fails to pay, it is our duty to inform the court that such and such reason party could not come. My lord, as
You
an
take
amicus-
instructions on VC. We'll have it on Wednesday next.
Thank you, Lord.
Okay.
19th, my lord, 19th.
Or we'll issue notice, but we are not adjourning the, staying the proceedings.
Issuing notice will not serve our purpose, but
Or you take instructions.
My lord, I'll have it.
Third three. Sen, BK Sen, learned counsel for the petitioner who has filed this application under section 24 of the Code of Civil Procedure, praying for transfer of FC Civil number 9882, So from family court, from Principal Judge Family Court number 3 to court number 7. Full stop. It is submitted that the petitioner wife has already instituted 2 cases at Bongaigaon, one for divorce and the other for maintenance. Full stop. It, however, appears that the petitioner is a graduate and aged about 34 years. Full stop para. On the option of appearing through video conference, the learned counsel for the petitioner prays for and is given 2 weeks time
My-
to obtain instructions. Full stop. List after 2 weeks.
Highly of it.
Yes, State Bank of India.
My lord, the impugned order is at two 110.
Why CRP?
My lord, what happened? The pro forma defendant has availed loan from the bank in the year 2012.
2012,
2012, and he has created equitable mortgage over his property.
yes, former defendant, he took loan
Yes, ma'am.
and
And he
equitable mortgage created.
Yes, ma'am.
Okay,
Thereafter, on 31/8/2014, the loan become NPA
2013,
14,
14,
14
NPA.
NPA. Then we have initiated action under section 13 to surface here. And we have also filed original application before the Debt Recovery Tribunal at Guwahati. And on 31/10/2018, a recovery certificate for rupees 27 crore.
2018.
Uh, yes, ma'am. 31/10/2018.
31/10/2018.
Recovery certificate for an amount of rupees 27 crore 30,68,318.162 was issued, and there it was held that certificate amount should be realized by selling the mortgage property.
Hmm.
Accordingly, the recovery officer has attached the property.
Hmm.
Then we came to know that there is a simultaneous proceeding before the district judge, Mangaldoi.
Oh.
And that proceeding was initiated on the basis of an award passed in the Calcutta. And at the time of execution of
Award in an arbitration.
arbitration,
What was that award? Who was the applicant claimant in the arbitration?
respondent number 1,
They are what?
my lord.
Respondent was 1 and 2 were on the basis of the proceeding.
They,
under the-
they had supplied the goods to the pro forma defendant, and on that arbitration proceeding was initiated.
R1 and R2 had instituted arbitration proceeding
Yes, my lord.
at Calcutta.
At Kolkata,
Hmm.
during the execution proceeding,
It was awarded
awarded.
ex parte.
So they were contesting. We were not party of that
No,
arbitration.
no, we know, but it was an ex parte award or what?
No. Contest.
Contested. Then
Then during the execution proceeding,
of the arbitration award.
yes, my lord, the pro forma defendant said that he is having immovable property at Mangaldoi,
Hmm. The execution is at Kolkata.
at Calcutta.
Okay.
He is having immovable property at Mangaldoi,
Hmm.
and so that execution proceeding has to be transferred before the court of district judge Mangal.
Yes.
That matter went to the Honorable Supreme Court, and Honorable Supreme Court held that Court of Session should be the Mangaldoi. Only that observation is there. When we come to know that simultaneous proceeding is going on,
Now, why did the matter go to the Supreme Court?
because earlier when the petition for transfer of the matter to the Mangaldoi Court was rejected by the Calcutta High Court,
Okay.
then it went to the
Okay.
Supreme Court.
Okay.
During pendency of the matter, Calcutta High Court transferred the matter to the Honorable Supreme Court. Order is I have enacted.
Okay, you have seen that.
Then one of our advocates filed one petition that bank want to file objection in the present case. And that petition was rejected by the district judge, saying that there is order of Honorable Supreme Court,
Hmm.
but the order of Honorable Supreme Court doesn't say that district judge has not to look after objection. So we have filed one petition under Order 21, Rule 58, and that petition was rejected, holding that why not we have filed objection, appeal against the earlier order. My humble submission is that earlier petition was for only for the adjournment. We had filed petition that we will file objection, and that was rejected. And this petition was filed under Order 21, Rule 58, because DRT is having jurisdiction and we are having certificate. But the learned district judge had
What is
rejected.
the certificate date? Is it 30/10/2018?
Yes,
And the award, date of the award,
and one thing, Your Lordship,
date of
And
the
the-
award in the arbitration?
it was in the 2014, but the property is mortgaged with the bank.
No, understood. The arbitration award is dated what?
It is in the 2016-17, like
Prior to your certificate.
prior to my certificate, but the property is mortgaged with us, and that is only money ticket. That was passed in the money ticket, not other. And before the Calcutta High Court, this pro forma defendant has suppressed the fact that the property is mortgaged. And by doing that, he has committed fraud. So we
Mr.
have taken-
Chalia, you are for whom?
I'm already respondent. Main respondent. One.
Who, you are armed with the award.
Yes.
You have an award in your favor.
Right.
You want to
And
execute
that
the
is being-
award.
That's being executed at.
Okay. Okay. Anyone for the pro forma respondent,
No,
defendant?
they are not appearing there. Before the district judge, they are not appearing.
But why have you made him a pro forma defendant here?
My lord,
Pro forma, he is a
because
respondent.
execution case is filed by this Rajni Pratap.
Understood. Man, in these proceedings, is he a pro forma respondent? Why?
Because they are not contesting there. They are not contesting our claim.
Doesn't matter.
They are not contesting our claim. And I have annexed the,
Okay, we'll issue notice here.
and
What is the stage?
you know, they are going to attach the property and sell it. So the proceeding has to be,
Spend is really going on.
so that has to be established.
No. Nothing at this stage, Lord. I will file objection.
No, but we will protect the property in the interest of both the parties.
Yes, sir.
If it is sold, bank will
No.
get nothing.
Because. they
No,
have
no
given
final
one-
orders, no final. What is the stage exactly? Oh.
It is for, attachment is already done for sale of the property.
Okay, no sale, okay. Heard. 3A Parvez, Learned Counsel for the petitioner who has filed this petition under Article 227 of the Constitution of India, challenging inter alia an order dated 26/2/2024 passed by so-and-so, cost title proceeding. Para. There is a checkered history in this case, full stop. Para. In the year 2012, the pro forma respondents had took a loan and the property in question was put to equitable mortgage.
Yes.
Full stop. As the loan had become NPA, apart from initiating a proceeding under the SARFAESI Act, a recovery proceeding was also filed in the learned DRT. Full stop. In the said OA number, original application number
1/8.
1,
One 183, 2016.
1,
183,
180 in the say OA number 183 of 2016, a recovery certificate was issued on 31/10/2018. Full stop. It was observed that the recovery be made by selling the mortgage property. And accordingly, the property was attached. Full
Yes.
stop. It however transpires that in the meantime, the respondent numbers 1 and 2 herein had instituted an arbitration proceedings against the pro forma respondents pertaining to a contract in which the arbitrator at Kolkata had passed an award. Full stop. when the award was put to execution, comma, the pro forma defendant had projected that there was a property at Mongolway which could be the subject matter for execution of the awarded amount, full stop.
No, they didn't say that. Only court held that since the property are in Calcutta, not in Calcutta. And
No, who
their execution
indicated?
Cannot,
Now, how did the court know that there was a property of the defendant in
Pro
Mongolway?
forma defendant.
they issued some, they wanted some schedule for execution of the,
That is,
No,
it has to be disclosed by the
Then-
pro forma.
then it was disclosed. by the-
Disclosed, that is only said,
Well-
that thereafter, comma. Thereafter. In terms of certain orders by the Honorable Supreme Court, comma, the execution proceeding was transferred by the Calcutta High Court to,
My lord, Calcutta High Court has earlier declined to transfer. Subsequently, when the matter was
No,
when
no, that we have said,
I-
ultimately it was transferred or not?
transferred, yes.
That is it. We said Supreme Court. Thereafter, the Honorable Calcutta High Court had transferred the
Okay.
proceeding to the court of the learned district judge.
Yes.
Comma, Mongolway, wherein the execution for the same property is going on. Full stop. Para. It is submitted by the learned counsel that the present execution case would frustrate the recovery certificate dated 31/10/2018 inasmuch as the property in question was the subject matter of the mortgage,
Along with this property, not, there were other properties also
we will say.
of the other director
Of
that
the
were
mortgage,
also
mortgage.
in the,
Full stop.
in the
Para.
execution.
Para. Let notice be issued, returnable on today's 12th. Returnable when do you want? On 17th, is it okay? 17th of July? Immediately after the vacation,
My lord, fine.
on 17th of July. Mr. Chaliha, you would be appearing for whom? One,
For
two,
this-
and three.
120.
Sri I. Borthakur, learned
My
counsel,
lord,
yes. Assisting Sri D.P. Chaliha, learned senior counsel. Accepts notice on behalf of respondent numbers 1, 2, and 3. Let extra copy of the petition be served upon him within 2 days. Let steps for service of notice upon the respondent numbers 4, 5, 6, and 7 be taken by registered post with AD. Steps within 2 days. Full stop. Para. Sri Parvij prays for an interim order. Full stop. Para. Sri Chaliha, the learned senior counsel, has however submitted that the execution proceeding qua the arbitral award consists of other properties also, and therefore no interim order is required to be passed. Full stop. Para. However, considering the facts and circumstances, comma,
Only below.
it is directed that till the returnable date, comma, the further proceedings in
No, let-
money
let it-
execution case.
Can it be this way, my lord?
Now we are making an observation. Money
Only the
execution.
sale-
Just
sale-
listen to
sale- don't-
listen to the court.
Fine.
Money execution case 2 of 2019, pending before the court of the learned district judge Darang, shall remain suspended. Full stop. Para. Three. The respondents may, by affidavit, clarify which are the properties which are beyond, which are not part of the recovery certificate, and pray for suitable modification of the interim order. We'll modify it. You just pointed out by an affidavit.
There's a caveat that
Okay. Heard Sri D.P. Chaliha and senior counsel assisted by Sri I. Borthakur, who has lodged this caveat in respect of an order dated 26/2/2024 passed by the learned district judge Dorang Mongoldoy in money execution case number 2 of 2019. Para, the caveat is would be heard in the event this court proposes to pass an interim order. Para, caveat stands discharged. You take steps, Mr. Parvez,
Yes, sir.
immediately.
I will take. My appeal, Lordship. In this case, Lordship, petitioner is equipped with the order granting interim maintenance under section 24 of the Hindu Marriage Act. Petitioner filed a divorce petition before the family court Pasat filter. In that case, the wife filed this petition,
Petitioner is the husband.
husband
File divorce petition.
divorce petition,
Where?
family court filter.
What happened?
Wife filed written statement and then a petition under section 24 of the Hindu Marriage Act.
Petition under section 24
24.
of HMA. Okay. Then
That was granted, although amount is 10,000 monthly maintenance and 15,000. But our main ground is
what
that
is
wife-
10 for?
10 for as monthly maintenance
Oh,
and 15,000 cost of proceeding.
cost. Okay.
Our main ground is that section 24 of the Hindu Marriage Act, if the spouse has independent income sufficient to maintain, then is not entitled for maintenance. This is the only ground we're challenging.
What do you do?
I had a school. Actually, my father established a school in Silchar town, South Point School. South Point.
Okay.
After the death of father, in the year 2017, management of the school was reconstituted with me, my mother, my wife, and my daughter as partner.
Yes.
And she was earning from there as a remuneration also. I will talk from the top. Now, our relation became in the 2000.
Is the wife still in the
Wife in
manage-
my residential property.
No. Is she still in the management of the school?
Yes. She is,
Presently.
yes. I have been ousted from the school, from my residential property. Now I stay in Kolkata. There I have a flat. And she is,
No, from the management, whether you are staying in Calcutta or Silchar, that is not.
I am not in management now.
Petition is not in material.
Not in management now. They have changed the earlier PAN number also. New PAN number is obtained and new,
What is your income source?
there is tuition. I have annexed my competition, ITR and
You reside at Kolkata. What
Kolkata.
is your income?
tuition,
Tuition.
and he is doing freelance.
Only tuition.
Yes, freelance and freelance reporting also.
Journalist. But you have filed at Silchar.
Silchar, because marriage was solemnized in Silchar. She has been residing in Silchar, and my residential property is also Silchar. She is residing there. I have been ousted from there.
You have married again.
No, I have not met. Allegation is there
I
is some.
think.
There is something.
I think
Allegation is there.
you have married happily. You are staying at Kolkata.
Under compulsion. There I cannot stay. In Kolkata, I have a flat. It is true, I have a flat, so I can.
But is it a happy marriage? The second one.
There is no marriage, Lordship. There is no marriage allegation is there is something, and that too in Silchar. In some teacher of the school. That is the allegation.
Okay. Now, what is the income of the wife?
Wife, Lordship, I have annexed, Lordship, this ITR, previous ITR, Lordship.
Of the wife.
Wife is also there, I am also there, previous 2018-19, and now
ITR of the school.
school.
No, that will not
Plus,
be.
from their remuneration and drawing is there. Remuneration is
How
shown.
much was the remuneration drawn by the wife?
Now,
Annual
recently,
share
she has submitted before the family court,
Hmm.
2,40,000 she has been drawing.
per year.
2,40,000. This comes to 20,000 per month and her daughter 20,000.
They've been,
Her daughter means your daughter.
yes, my
not her
daughter.
daughter.
Sorry, our daughter, 20,000.
You have a daughter.
Yes, daughter, one
How
son.
old?
She is BE with MBA. She is not doing any other work, but she is also with mother. in
She's
school.
grown up.
He has grown up. And one son, he is also major.
Two words. One son, one daughter.
One son, one daughter.
Two children.
Two children.
The son,
Son is 18 years, 19 years old.
student. Do you pay separately for these children?
Yes, I pay sometime.
I think 10,000 is less. We will issue notice. Why should it should not be enhanced? You have two children.
Another thing, Lordship, why I am pressing also.
You have any other children
No, Lordship.
through anybody else?
She has changed the school pen number of the school. There's suppression in her ITR also.
But do you think that 10,000 is on the higher side?
Because he is an independent income, that's why. And
You have not been able to show
she
what
is
is the
she was using my residence also.
residential house is not an income. How she has to live with two children.
And
What about your parents? Your mother?
mother expired in 2021. Mother expired.
Not a fit case. Interim maintenance.
Page 92, Lordship, it is there that
You're lucky. It is at 10,000.
capital introduced 9,70,000.
Not a fit case, Mr. Purkasta. We're closing this. Sri SG Purkasta Learned Counsel for the petitioner who has filed this petition under Article 227 of the Constitution of India, challenging an order dated 22/4/2024 passed by so and so. এই report লিখে দেব। এখানে post title, no? Para. Oh, you're 63 years.
63 years. He is 50 years.
You reside at an NRI complex.
This is the West Bengal government.
NRI.
Name is
NRI stays for something else or what?
it's urban something. NRI Council, Urbana NRI. It is in lease. West Bengal government is the owner.
Oh, okay, doesn't. The Learned Council has submitted that the petitioner, that the father of the petitioner was running a school in the name and style, South Point School at Silchar. And upon his death, the management was entrusted to the petitioner, the respondent, and his mother. Full stop. Due to some disputes, the petitioner had shifted to Kolkata and thereafter has instituted a proceeding for divorce in the family court at Silchar. Full stop. During the pendency of the said proceeding, the respondent has filed an application under Section 24 of the Hindu Marriage Act. Full stop. In the said petition, interim maintenance of rupees 10,000 per month. And interim maintenance pendency light, 10,000 per month has been granted, and another amount of 15,000 as cost. Full stop. Para. It is submitted that the aspect of the income of the respondent wife was overlooked by the learned principal judge, family court, while passing the impugned order. Full stop. It is also submitted that the respondent is having a decent income from running the school in question, and the petitioner has in fact been ousted from the management of the said school. Full stop. Para. Upon consideration of the matter, comma, it transpires that the parties are also having two children who are living, though the petitioner has submitted that he does not have a fixed source of income, comma, in the considered opinion of this court, comma, the amount involved for maintenance penalty light of rupees 10,000 does not from any angle appear to be on the higher side. Full stop. The cost of rupees 15,000 also appears to be reasonable. Full stop. Para. In view of the above, comma, this court is of the opinion that the jurisdiction exercised by the learned court below was in accordance with law. Full stop. The powers to be exercised by this court under Article 227 is a power of supervision, and only to ensure that the courts below act within the four corners of law. Full stop. Para. The instant impugned order does not appear to be in excess of jurisdiction, and rather appears to be reasonable and as per law. Full stop. Petition is accordingly dismissed.
Item 5.
Happy thought. My lord, the matter pertains to the discipline of the officers of the food court. My lord, the petition is an advocate lordship. My lord, he filed at the time of filing of the title suit lordship, he was an advocate lord, filing advocate lord. At the my lord stage of my lord written statement lordship, another set of counsels were engaged by the my lord plaintiff without any information, without my consent of the petitioner lordship. Directly the plaintiff submitted application before the court lordship for leaving to sought for leave my lord to file Vokalatna on behalf of other advocate lord. Now that was granted lordship. Kindly see page 51. I submitted objection lordship saying that I did not give consent. The relation between the my lord litigant and counsel was not
Page 51.
51 lordship.
This is the impugned order.
Impugned.
Yes.
My lord, may I read lordship? It appears that today the case was posted for order on petition number 1174 of 2023, dated 13/10/2023, filed by the plaintiffs for the sense of their original engaged counsel, made a shift of grounds set forth in the aforesaid petition. Gone through the objection filed by the original engaged counsel to the aforesaid petition. Also gone through the relevant documents relied upon by the parties to substantiate their contention. The case of the plaintiff petitioners in brief is that their original engaged counsel had asked for his legal fees and they had already paid fees. So it is not desirable to allow the original engaged counsel to conduct the case on behalf of the plaintiff. Hence, they sought for his termination, discharge from this case. Whereas the case of the original engaged counsel opposite party, on the other hand, is that his discharge from instant case is not maintainable in view of Rule 12 of Guwahati High Court Conditions of Practice of Advocate Rules 2010, as he has not given any NOC, nor he has given up his service to the plaintiff. Heard the learned counsels for
Go ahead,
both
go to-
the side in respect of their contentions.
Rule 12 of the Guwahati High Court rule to condition and practice of advocate.
My lord, Rule 12, Lordship.
Just one minute, please. Asana. Yes.
My lord,
Fine.
my lord, rules of disorder, Lord.
Yes, please. Please read the Rule 12.
Well, Rule 12. No advocate shall be permitted to file an appointment or memorandum of appearance in any proceedings in which another advocate is already on record for the same party, except with the consent of the former advocate on record or the leave of the court, unless the former advocate has ceased to practice or has by reason of infirmity or mind or infirmity of mind or body or otherwise become unable to continue to act.
Hmm.
My lord, three parts, Lordship.
Hmm.
One is, my lord, without no NOC, Lordship. Another, my lord, is, my lord, leave of the court, Lordship. My lord, leave of the court, my lord, when comes, Lordship? When the, my lord, in my humble submission, my lord, when the, my lord, litigant, my lord, approach, my lord, to NOC, has my expressed, my lord, no confidence, then it is my duty to, my lord, hand over the brief and issue NOC, Lordship. That, my lord, issue does not arise yet, my lord. No notice, no nothing was there, Lordship. Directly an advocate was engaged, my lord, then I, my lord, submitted complaint, Lordship. So leave of the court, that stage does not come, Lordship. The court, learned court below, Lordship, directly granted leave, saying that it is not, it is in the interest of the litigant, Lord. Now, this is not permissible, Lord. The Honorable Supreme Court, my lord, and the same, my lord, problem arises in the arising in, my lord, Odisha High Court, Lordship. The Odisha High Court also has, my lord, held that the without NOC of the erstwhile counsel, my lord, no other set of advocates cannot be permitted to, my lord, appear. My lord, in the my lord, in that case, Honorable Supreme Court's order was, my lord, also followed. My lord, one para judgment order of the Honorable Supreme Court was also there, Lordship. My lord, clear circumstances does not, my lord, my lord, Honorable Supreme Court judgment order, kindly see first clause. One page, one paragraph for that, Lord. That is 1996 6 HCC 755. May I read, Lordship?
Just a minute, please.
1996 6 HCC 755.
M. Purna Chandran. Okay, which paragraph?
My lord, only single paragraph, Lordship. May I read, Lordship? The record of the appeal indicates that the Sri Sudarshan Menon was the advocate on record when the appeal was heard and decided on merit. The review petition has been filed by the Probir Chaudhuri, who was neither an advocate arguing at counsel when the appeal was heard, nor was he present at the time of review petition. The argument. It is unknown on what basis he has written the grounds in the review petition, as if it is a hearing of an appeal against our order. He did not confine to the scope of review. It would be not in the interest of the profession to permit such practice. That apart, he has not obtained no objection certificate from the advocate on record in the appeal, in spite of the fact that registry had informed him of requirement for doing so. Filing of the no objection certificate would be the basis for him to come on record, Otherwise, the advocate on record is answerable to the court. The failure to obtain the no objection certificate from the erstwhile counsel has disentitled him to file the review petition. Even otherwise, the review petition has no merit. It is an attempt to re-argue this matter. My lord, our case is better than this, my lord, because it is a review petition, my lord. Earlier litigation was over, lordship. Even then, the Honorable Supreme Court says that even after filing of the review petition,
Here, there is a clear observation regarding the consent of the advocate on record.
on record, but in our High Court, my lord, the advocate on record. my
So
lord, this-
who is an
this
advocate on
clear.
record?
Now, my lord, the
Just a minute.
signature of the
Well,
advocate, filing and.
Just
my lord,
a minute, just a minute.
yes.
Who is an advocate on record?
My lord, advocate of this is a Supreme Court, my lord, correct. Only filing is allowed in Supreme Court by the,
Advocate on record is the person who files it and whose name is in the
Yes.
wakalatnama. Here, we do not have the practice of advocate on record, but the person who has filed the case and is on the named in the wakalat, they are the advocates on record.
my lord,
Here in this case, the review was filed by another, was presented by another advocate. There was no consent from the advocate on record. Under those circumstances, these remarks have been made.
here in this case, our case is more better, lordship,
No,
because
but-
the same litigation, lordship.
But Mr. Counsel, just tell us one thing. Can you force a litigant to have you as a
No
counsel?
lordship, no lordship. My lord, this is the judicial review, discipline, lordship.
So ultimately,
Otherwise, chaotic situation with the
ultimately, what is the result you are expecting? That you should be allowed to appear?
That procedure should be there, lordship.
No, you
Unless-
you will force somebody to have you as the counsel.
My lord, the litigant must, my litigant, my approach me.
This
my
should
lord.
be again the very essence.
My lord,
a
in the directly in
person-
the
a per-
court, lordship.
How
My
can
lord,
we,
part time,
how
directly,
how can you put fetters on choosing a counsel?
my lord, that is, because my lord, I am, my lord, conducting a case, my lord, another
can you-
advocate is
can-
coming, my lord,
can you
chaotic
force
situation will be
yourself?
there, lordship.
Can you force yourself to decline? No,
No,
no, I
ma'am,
will be
I
a
am not
counsel.
forcing, lordship.
Yeah?
But she.
You should have
But she or he must, my lord, approach me, lordship.
with all dignity, you should have come out of this thing.
Dignity,
You-
kindly the judgment of the Honorable Odisha High Court, lordship.
You
This
have
is clear.
come with a revision of
This
this
is clear,
nature.
lordship.
Now, where is the bar to give leave by the court? Tell
The-
us. If
the
you are
court can
forcing
give leave.
yourself as a
My lord,
counsel,
the court can give leave, but the circumstances should arise, lordship. Here in the circumstances did not arise, lordship.
they do not want you as a counsel. Matter ends there.
My lord, the,
Can you force yourself to be the
my
counsel?
lord, no convenience should be expressed to me, lordship.
Not
You-
necessary.
My lord,
No,
Odisha
that-
High Court
that-
judgment kindly see, lordship.
That will be against the very essence of choosing. Can you,
But otherwise,
can you
unless
put
this
fetters
issue,
on choosing?
my lord, unless this issue is decided, my lord, the chaotic situation will be arising.
Let
in
there
all
be,
aspect, my
let there
lord,
be a chaos. If you
the
say
practice
chaos, let there be chaos. If you force yourself to be a counsel, let there be chaos.
My lord, cannot force. My lord, now,
Then if you cannot force, where is the chaotic situation? You are creating a chaotic
my
situation.
lord, I am appearing. My
How
lord,
can
somebody
you
will
force
come and,
yourself to be the counsel?
without
Just
my
tell us.
consent.
Tell us.
My lord, first
If
thing-
a client doesn't want you as a counsel, can you force that I will be a counsel?
my lord, I.
Why
cannot-
is the counsel
No,
appointed?
I cannot force.
No, why is the counsel appointed? To protect the interest of the client. If the client does not have faith upon you, can you insist that no, I have not given no consent? So you
I-
cannot engage anybody else.
My lord, what?
This will be chaos.
No, what I am, yes, that should be clear. Now, what I am submitting, lord.
Okay.
What I am submitting, lordship.
Yes.
My lord, at least the Odisha High Court judgment, my lord. Everything
have
is
seen-
discussed here, lord.
Not a fit case.
My lord, Odisha High Court
Not a
judgment.
fit case for to give more time than this.
My lord, notice may go, my lord. Notice may go, lord.
You'd be lucky if we don't impose cost upon you.
My lord, my lord.
You are
this is
asking about notice. You are wasting judicial time for matters of this. What would be the end result? Tell us. Will you gain anything? Will
Nothing.
anybody gain anything?
Only, my lord.
We are losing judicial time.
My,
A
nothing. my
client
lord.
doesn't want you as an
This-
advocate.
this is
How can you
distinctly,
force? Just answer this. Suppose you win this case. Suppose we decide this case in your
dignity- my
favor.
lord, dignity of the court should be maintained.
You should have come out of it. Somebody doesn't want me as an advocate. Why should I stick to it?
My lord, I have also a dignity, lordship. That is.
Dignity is dignity to maintain the dignity. You come out of it. Matter ends there. Will you fight in the court? No, I want to be your advocate.
That is, lordship. If somebody express no confidence, lordship.
And have you
then
engaged
this is my-
somebody else?
This is my duty, lordship.
And Mr. Ahmed, have you engaged somebody else in the court? Or are you appearing yourself, for yourself, in your case?
In this case, lord.
In your case,
No,
who is
no.
the council?
No loss.
Who is the party?
My lord, parties are my lord, plaintiff lordship, plaintiff 1 and 2, my lord, the
No,
council
no,
also, the
Ismail Haq is a council.
councils are also.
He is the aggrieved party here.
Okay.
Now, if he doesn't want you tomorrow,
Yes, this is my duty, lord.
then,
This is my duty, I will handle back.
yes,
But
answer has come from
my,
me.
but the litigant must express lordship. Lordship,
What
my-
more? What more? They have
Notice
engaged
should be
somebody
given.
else. What more is to required? We do not know what has happened. Maybe how many times they have gone to you.
That is why lordship, the honorable, every high court judgment kindly take.
Heard,
It may be, my lord, taken note of
you
lord.
should not have come to this court with this matter.
My lord, that judgment may be taken.
Heard, yes, heard Sri M.H. Ahmed Learned Counsel for the petitioner who has filed this application under Article 227 of the Constitution of India, challenging an order dated 22/4/2024 passed by the learned civil judge Zubri in TS number 7 of 2023. Full stop. By the aforesaid order, comma, leave has been granted to the respondent to engage
My lord,
another counsel.
my lord, if your lordship, my lord, goes against lordship, then I may be allowed to, that are, it will be precedent lordship.
We want to set a
Every
precedent.
advocate will be, my lord, affected lord.
We want to set a precedent. You should not come to this court. We have heard your length more than half an hour. We are not going to,
Otherwise, my lord, it will be precedent lord.
para. It is submitted that the petitioner, who is an advocate, was initially engaged by the respondent numbers 1 and
1 and
2,
1 and 3 lord. 1 and 3.
1 and 3 to represent themselves in title suit number 7 of 2023. Not 1 and 3, 1 and 2. 1 and 2, full stop. However, comma, during dependency of the suit, comma, they wanted to engage respondent numbers 3 and 4 as their counsel, and accordingly, the application was filed for leave of the court for such change of counsel and engagements of the respondent number 3 and 4, full stop, para. It is the case of the petitioner that the respondent numbers 1 and 2 did not seek any no objection from the petitioner, and without such no objection, comma, new counsels could not have been engaged, full stop. The learned counsel has referred to Rule 12 of the Guwahati High Court within bracket conditions of practice of advocates bracket close rules 2010, full stop. Reference has also been made, and a reliance has also been placed upon the judgment of the Honorable Supreme Court in 1996, 6 SSC 755 within bracket Namdiba, and another judgment of the Honorable Odisha High Court in so-and-so, full stop, para. The learned counsel accordingly submits that interference of this court may be made, full stop, para. It transpires that in the aforesaid suit, comma, the petitioner, who is a counsel, was initially engaged, full stop. It also transpires from the materials on record that the said respondent numbers 2 and 3, 1 and 2, had chosen to change their counsel, full stop. It is submitted. Now, in the context of the submission made, that the petitioner did not issue any no objection certificate, comma. The Rule 12 of the aforesaid rules may be examined, full stop. For ready reference, comma, the said rule is extracted here and below, full stop. Para. As per the said rule, comma, no advocate shall be permitted to file an appointment or memorandum of appearance in which another advocate is already on record, save with the consent of the former advocate on record or the leave of the court, full stop. The rules has contemplated a situation wherein the consent of the former advocate may not be given, and under those circumstances, comma, the provision has been left for the court to grant leave, full stop. Para. The party, a litigant, is free to choose his advocate, and no advocate can claim any lien over any lease, full stop. It would be an absolutely unreasonable proposition that only on account of non-issuance of no objection certificate, comma, and another advocate may not be engaged by the party in accordance with law, full stop. Para. The reliance upon the case of M. Purnacharan Supra is wholly misplaced, full stop. In that case, comma, the Honorable Supreme Court was dealing with a review petition in which appearance was made by a counsel without the no objection by the advocate on record, full stop. It is under that context that the Honorable Supreme Court had dismissed the petition, full stop. Para. The case of the Odisha High Court thought to be relied upon is not applicable as the facts are entirely different, full stop. Para. As held above, comma, the litigant has every right to engage a counsel of his choice, and no fetters can be put on such exercise of discretion, full stop. In the considered opinion of this court, comma, no case for exercise of the jurisdiction under Article 227 of the Constitution of India is made out. Petition is accordingly dismissed. Odisha to my love likhi dim de. Yes.
My lordship. The lordship, kindly matter be adjourned for the actually Mr. Begum. Please not well. She was about to come, your lord.
Item number?
6, your lordship.
Who is not well?
Mr. Begum, your lord. She was about to.
Lordship, in order 41 rule to hearing, humbly, my lord, their role is very limited.
It's an RSA.
It's an RSA admission. But it's on the satisfaction of
No,
the
even if
court.
she is there, will we hear her? Will not hear.
She has to say something, your lord.
We cannot.
At this stage, not.
Unless we frame substantial question of law, after framing, we'll hear you while we adjudicate on those substantial question of law. See the sequence of 100. Your role for hearing or right of hearing will come after framing of the substantial questions. At this stage, you do not have any role.
Please for the day, your lord, on Friday.
Okay, for his satisfaction, let her be present.
And Lordship, one thing I just want
But
to.
you will not be allowed to say anything.
But her presence, please.
We'll
Her
not even
presence, your
record
lordship.
presence. We'll say if he makes out a case for admission on substantial question. At best, you can accept notice, nothing more than that.
And Lordship, actually what had happened in this case was already admitted if Lordship sees the previous order. But inadvertently, the substantial question of law was not framed. And therefore, again, it is
Which order?
the first order.
Oh,
It's an admitted case.
oh, it's already admitted.
But as per last order, your lordship, again, this case was
The learned counsel of substantial admitted to the No, it's only for framing question, substantial
The
question. See,
question.
the court has expressed its mind that the appeal warrants an admission. It has been admitted. The order has not been placed for, filed for any review.
No.
So we'll frame substantial, we'll frame it in her presence. Have you made any
Yes, yes.
substantial questions?
Yes.
Have you
That is,
formulated?
yeah,
Page,
page 6, the first question. Lordship, actually what had happened here, the we were
okay, we'll hear you in her presence. When?
all
any day next.
Next week, Friday, this Friday, day after tomorrow. Okay.
Problem.
Otherwise also you do not have any scope of addressing, and after this order of admission, a prayer for adjournment has been made on behalf of Ms. F. Begum, learned counsel for the respondent numbers 1, 2, and 3, full stop, para. List on Friday.
Oblige,
Date,
oblige.
huh?
May please smile. The appeal was already admitted, my lord. We have filed a cross
Oh,
substantial question
Yeah,
of law is
okay, you have a cross objection.
cross subject.
Okay. And so far as Mr. Mukit's
My appeal is already admitted.
admitted, okay. Yes, so you have any formulated any questions?
Page number 3.
Yes, what do you say?
My lord,
Otherwise, scope is very less, but since your appeal is already been
Already admitted, so
admitted,
let it.
we'll admit this,
my lord,
we'll hear it together.
Page 3, my lord, first subject.
Page 3.
Page 3, first one will suffice.
Why do you miss out the D, Mr. Iqbal?
Hello?
Where is the D? Page 3. Propose.
My D is back.
Whether the learned appellate court was legally correct in deciding the suit for recovery in spite of declaring that the respondent has right. Was there a prayer for recovery?
My lord, recovery was there. I had sought for declaration of right title interest in respect of Schedule P plot of and recovery of possession in respect of Schedule P
You
plot.
are the plaintiff.
I am the plaintiff. My
You had
declare-
sought for recovery also.
my
No
declaration-
decree on recovery.
Not given.
No, what about the, that was in the suit?
That was it.
Then what about the first appellate court?
My lord, in the suit, it was dismissed, my suit was dismissed. So in
Suit
the
was-
first appellate court held that, my lord, I have right title interest over
Oh,
Schedule P.
you are the plaintiff, so dismissed, you come up in appeal,
Appeal, my lord. In
and
the
appeal while deciding the issue of right title interest, recovery has not been,
Not given, but
okay,
the court has held that I have right title interest.
okay.
Once, my lord, I
And Mr. Mukit, what was your questions?
my lord.
You are the defendant, suit was
I'm
dismissed.
the suit was
In the
dismissed.
first appellate court, what has happened?
First appellate court, my lord, has only.
You are challenging this recovery, this first part also, declaration?
Yes. The
Okay,
reason being-
we'll admit this, okay. Hard. This is item number 3A, Iqbal, learned counsel for the cross objectors, two numbers or
One, my-
one,
only one.
cross objector who has preferred this objection in RSA 218 of 2023. Full stop. It is submitted that the aforesaid RSA has already been admitted on certain substantial questions of law. Full stop para. It is
Ordered-
submitted
Order dated is 12/1/2020.
by the order dated 12/1/2022. 24 para. It is submitted that the present cross objector, who is the respondent in the RSA 218 of 2023, had instituted the suit for declaration of right, title, and interest and for recovery of B scheduled land. Full stop. While the suit was dismissed, comma, the first appellate court in the appeal preferred by the present objector, while decreeing the suit, had not passed any decree for recovery of possession of the B scheduled land, in spite of a specific relief being sought for in that regard. Para. The appeal is admitted on the following substantial question of law. Act number 2, call page 3. One any other, you would be accepting notice. Sri Jad Mukit, Learned Counsel,
Only for, not for.
Learned Counsel, who appears for the appellant in the connected RSA, accepts notice on behalf of respondent number.
One in, one,
Only 2 respondents, I think,
one in.
for the respondents.
For the pro forma date, I think.
There is no problem.
For honor.
Respondents. Para. Let an extra copy of the memo of appeal along with the connected document be served upon him within 2 days. List along with RSA 218 of 2023. One bully to question on the following substantial question of law. Normal task any other question to normal line of law. Yes. Mr. Mahmood, what is this?
My lord, this is second appeal by the appellants. Concurrent finding is against us. The other day, my lord, when the case was listed in court number 17, I was asked one question that when our clear case is that our purchased land has been also made subject matter of the partition. But when the honorable court said me, where you have claimed that your purchased land is also within the decreed land, I could not say immediately because it voluminous file. Now we have discovered that that lordship may kindly see page 39.
First, let us know the basic. You are the appellant is the plaintiff.
I am the defendant appellant.
Appellant is the defendant in the suit. Suit for?
Suit for partition, declare after declaration of right, title, and interest.
Partition and declaration.
Yes, declaration, partition, and through commissioner. That was filed by the present respondent's legal heir.
By the predecessor and interest of the respondent.
Yes, by the respondent's mother and father.
Predecessor and interest.
Yes. They filed the case. In the meanwhile, they died. And so their children who are presently legal heirs have been made as the respondents in this second appeal matter.
Okay. Now, what was the decree of the first court, trial
Last
court?
court in their favor, in both the courts below, concurrent finding is against us.
Decreed by trial court.
Yes.
Affirmed by the appellate court.
Yes.
Now, what are your grounds?
My lord, my grounds, lordship may kindly see page 11. Yeah, my lord, 1, 3, and 4 is very important questions of law which were not taken up because here lordship would see
Now, you tell us the basic
page
facts.
82.
Basic facts, what has happened?
My lord, the one Abdul Ali, alias Abdul Mia, was the original owner of some plot of land. Thereafter, since the year after death of Abdul Ali, Abdul Mia, the present appellant and 3 daughters of Abdul Ali, they became the owner of that plot of land.
How are you connected with Abdul Ali?
Abdul Ali is our grandfather.
Or you are the grandchildren?
Yes.
How many appellants are there?
We had 3 appellants originally, but now they are, because they have, some respondents have also died. So their legal heirs have become the appellants here.
Okay.
That lordship may kindly
Then
slip.
the plaintiffs were his grandchildren.
Hello?
Plaintiffs were the grandchildren of Abdul Ali.
Yes.
On his death, you
Appellants are also the grandchildren of Abdul Ali.
No, that was even the defendants are grandchildren.
Defendants are defendants, appellants.
They had inherited the property.
They filed a case, and in that case, they have withdrawn the case on the ground that there was a amicable settlement outside the court. Then case was withdrawn.
No, Mr. Mahmood, go serially. You said Abdul Ali, alias Abdul Mia, was the original owner of a plot of land.
Yes.
He had passed away.
Yes.
After his passing away, you had
Abbas Ali, alias Abbas Uddin, who is the father of late Imanuddin and late Amiruddin and late Faizuddin. So they are the present appellants are the legal heir of this person, Imanuddin, and Inamuddin, Amiruddin, and another person that lordship would see.
They are the sons of Abdul Ali.
They are the son of Abbasuddin. Abbasuddin.
And
Abbasuddin is the son of Abdul Ali, alias Abdul Mia. So Abdul Mia died. Thereafter, his properties inherited by
Abbas
and the sister of Abbasuddin.
Abbas and his sisters inherited.
Yeah, and sisters are the plaintiffs. A plaintiff respondent.
Okay.
They claim that our
son Abbas and his sisters inherited the property on the death of Abdul Ali.
Abdul Ali.
Then,
now they claim that here is the share of the plaintiff.
Sisters are the plaintiff.
Plaintiff. They claim that. And we say that
you are sons of Abbas.
Abbas.
Oh, present appellant sons of Abbas.
Yeah.
Okay.
The learned courts below.
They filed the suit for partition and declaration of right title interest. Yes.
Now, lordship would say one important thing.
Why are you opposed to the partition?
No, partition we oppose because the land belongs to us. They have taken their land much earlier. They filed a case that is also numbered, title suit number 48, 2005.
Who? These sisters?
This is a plaintiff.
They had filed another case.
Earlier filed the case, and case was withdrawn on the basis of amicable settlement.
Title suit number?
Title suit number 48/2005.
48,
2005.
Earlier filed.
Earlier they filed. And
withdrawn.
Withdrawn because the matter was amicably settled. And a settlement was also made among the legal heirs of Abbasuddin.
Yes.
Then, my lord, here the learned courts below, lordship may kindly see page 82 for a moment, how the courts have interpreted the documents. Page 82.
Yes.
Exhibit C, deed number 609. So this 609 deed is our purchase land, our deed.
Yes.
So our deeds which were purchased by Inamuddin and Imanuddin and Aminuddin, they are the purchaser of this plot of land. That plot of land that has been exhibited, registered sale deed has been exhibited before the learned trial court, that is Exhibit C, deed number 609.
Yes.
Now, the land which were purchased by this person and Abbasuddin, those lands have been also made the subject matter of partition. So our case is very clear that the learned court bill has committed grave errors in making our purchased land as the subject matter of the partition. So that's why the substantial question law, Lordship may kindly see page 11.
You had purchased this, your father had purchased this land by deed number 609. From whom?
From, yes, one Saptera Khatun. One Saptera Khatun.
This has got nothing to do with your father's property.
Yes, the rest of the they said on 18 to 77.
Mr. Mahmood,
My lord?
this land has got nothing to do with the land of Abdul Ali.
Yes, so.
It's a
No
different,
connection at all.
different,
Separate land,
but it has been made a part of the partition.
part
suit.
of the partition.
Okay.
So that's why page 11.
But why was this not appreciated by the courts below?
Courts below, my lord, did not go into depth of the case. Very casually that they considered that as they are the legal heirs of late Abdul Ali, alias Abdul Ali. So that was taken. No serious.
This deed of 609, who are the purchasers in the deed?
Yes, that yeah, courts have also, my lord, the court has also observed this matter. Kindly see page 106 and 109.
One 106.
Yeah, 109. 106.
Yes.
Page 38, Roshibushi. DW2 further said that one part of the Sutland was inherited by their predecessor Abbasuddin. Rest of the purchased property of Abbasuddin and even the name of the Abbasuddin was recorded in the final khutiyat of first settlement operation. DW2 stated that even defendant number 1, 2, 3 purchased a part of the Sutland by registered deed number 609 dated 18 to 76 and the name of defendant number 1, 2, 3 are mutated in the office of Badarpur Town Committee and they are paying revenues to the government regularly. So our this is also the observation of the learned court below that this is part of the they purchased this land and there is a registered sale deed of the year 2000 of the year.
But Exhibit C, there is a discussion at page 40, paragraph 46 and 48. There is no description in Exhibit C.
Paragraph 48, there is
46 and 48, 109 at page 109.
109.
Please read.
Appellant defendants are further claimed to have purchased a part of the Sutland by registered sale deed number
609.
dated 18 to 77. I have also perused the said document which was exhibited by the Exhibit C, but the said document did not give any specific description of schedule of property and therefore I am in agreement with the finding of the learned trial court that it could not be ascertained that whether the land of deed number 609 falls within the suit land. Well, this is perverse.
Then 48. Read 48, read 48.
Now, as per section 101 of Evidence Act, since the defendants asserted that part of the suit land was purchased by their predecessor and by themselves, burdened to prove the same shift to the defendant side, but the appellant defendant side failed to show the purchase deed of their predecessor, and even Exhibit C is an ambiguous and cannot be ascertained whether the land of Exhibit C falls within the suit land. Now, Lordship, my submission is this. Both this para 46 and 48 are perverse finding.
Why?
Because that is a registered sale deed. And the court did not take the help of Latmandal or any revenue official that whether this land falls within the land sought by the trade deed. So how the court can say ambiguous? It is registered sale deed.
No, registered sale deed maybe, but he did not give any specific description of the schedule of the property.
Well, that's why lordship,
Covered, do you have a copy of the exhibit C?
that deed.
Yes.
Deed.
Let us see the schedule of the deed. Yes, topsoil code.
There is another Abbasuddin purchased land.
Now, where is the schedule? Where is the topsoil?
My
Here,
lord,
there is no topsoil.
not official, well, may I see the same for a moment?
Yes, yes, please.
And here, this is the land of Abbasuddin. Here schedule is there, Mouza.
Chandan.
I am giving to your lordship perusal. Mouza, Sabara Mia Bazar. চারদিকে 1 বিঘা 1 কাঠা সর্বমোট সহ মজুর রহমান গয়রহ উত্তরে আমার
No, that is exhibit. That is not exhibit C. This is exhibit C.
exhibit C. No, it is stated in our WS that part of the land has been purchased by Abbasuddin, our father, present appellant's grandfather, and exhibit C was purchased by Aminuddin Imanuddin. And here, lordship,
See the description in the
Description.
schedule.
yes, let me see. Yes, this is dear my lord. Porgona, Chanaghat, Mouza, Bakara, Bazar, Mardhigi, Mahal, ST 9912/2 নম্বর কালুরাম শর্মার সংক্রান্তে পূর্বে আপনাদের নিজ সত্য গৃহাংশ ইহার ভাড়াটিয়া মুদাসসির আলী পশ্চিমে থাপানা দেবনাথ দেব নিজ শতাংশ ইহার ভাড়াটিয়া আব্দুল হোসেন উত্তরে আমাদের নিজ সত্য দখলীয় ভূমি
There is no description. There is no Dag number, Patta number, which land?
let me say first. It may be efficiency দৈর্ঘ্য 10 ফুট 9 ইঞ্চি প্রস্থ মৌজার অংশ that means say the Dag number is there, my lord, in the main thing. In topsoil it is may not be given, it is
It
the
is not
sheet
there.
deed of 1977. So here are Dag number is here, my lord. I am saying, I am submitting there বাদীর 1475 নম্বর রেজিস্ট্রারি কবলা বুনিয়াদ মর্মে পিতা মস্কুরা খরিদ করিয়া মালিক সত্যবান হইল। তো নিম্ন so here topsoil lordship, my lord, here one thing 9912 because tag numbers many times changes with the passage of time. It is the deed of 1977. So my lord, here
No, change of Dag number is another issue, but mention of at least one Dag number, maybe the old Dag number.
my submission is how the court can say it is not. Court has not taken the assistance of any revenue staff
That is your
on the
document.
veracity of this document.
That is your document.
My document.
You have said that this is a separate land. Our father had purchased by 609 deed number.
Yes.
But 609 does not even describe any, has any proper description of the land in question.
The lordship may kindly fix the matter day after tomorrow. Let me go.
You go through, maybe there may be something in the
There is
narration.
also an invitation. Here this sale deed. Mutation order is also there. Let me go through that.
Okay, there may be
thereafter-
some
Yeah,
description.
that will be,
Okay, when is the next?
only one thing, 77 did, that is my problem.
Deed maybe of 77, description has to be there.
Description is there, but diagram or pattern number is not there.
Okay.
That is the question. Even then, whether I
Okay,
will select
on
the
the, on the,
mutation register,
on the request of Sri Mahmood, the learned counsel for the appellant, matter is adjourned to be listed on Wednesday next.
next problem.
Date
What,
19. 19 is okay for you?
no, I wanted the day after tomorrow.
Day after tomorrow, there are many matters. Day after tomorrow, not
Wait
possible.
on Friday.
Friday, there are many matters. Not
Right.
be possible. Yeah, on Wednesday next, 19th. 19 is okay?
19/6
19/6.
problem.
Yes, Mr. Upadhyay.
May I please, your lordship? See, here, concurrent findings is there, your lord. In both the court have passed the order against me, your lord. So here basically, the properties originally belong.
You have given corrected copies of the plain 10 WS.
Yes, I have corrected.
You have given. When?
That is there.
No, 22/4, there was a specific order. Learned counsel to submit, he may be given 4 weeks time to give better translated copies. Have you given?
It is in the petition itself.
Huh?
Basic question that. we
Just a
have-
minute, just a minute, please.
In vernacular language, there is the copy.
Only one page there was a problem or what?
Yes,
First page of the
first page.
plain as the written statement.
Plain and written statement, first page of the plain.
Yes, what is it? Who are you?
Yes,
Appellant is what?
I am the defendant. Original
Suit for? Suit for? Suit for?
Suit for declaration of right title interest and recovery of possession.
Recovery of position.
Yes.
Yes.
In this case, what happened, your lordship? Both the plaintiff and the defendant,
Yes.
the appellant and respondent are the brothers,
Plaintiff and the defendant brothers.
are the brothers.
Okay. You're the defendant is the brother of the plaintiff.
Yes.
Okay.
I am. So the father has 4 sons and he has some properties and at different places, at different patta and dag.
Hmm.
Now it relates to the original patta number 21. So this plaintiff has filed a partition case before the circle officer in the year 2006. The circle officer plus officers have not served any notice to any other persons, including the defendant. And the partition is allowed. And accordingly, he has filed this suit on the basis of the dag number and patta number of partition property. That is earlier 21, that has not been mentioned. So he has not stated, he has clearly stated that the above mentioned land in the Schedule 1 was within the same revenue map of Meadi Patta 21. Later on, as per order dated 16/2/2006 passed by the circle officer of Narayanpur Revenue Circle, the land was divided and separated. But in this case, no notice was served to the defendant and to the other brothers, and one sister is also there. Now, on the basis of the new patta number 145 and dag number 322, only his name appeared. And he did not exhibited the Jamabandi of patta number 21. He cleverly did not exhibit it because it will find out because the original owner is the father. So every son has the share on that particular land. But he has filed petitions for partition and that has not been exhibited. Now,
Partition or for mutation?
partition.
Initially,
Now,
before-
initially he has filed for mutation in the patta number 21. Then he filed partition.
the suit is for declaration of right title interest.
Right title interest. So this is a joint property. This is a joint property. Without the proper partitions, one of the legal heir cannot claim the rights.
Yeah,
over
why
that land.
recovery of possession? It was under the possession of whom?
Because it is under my possession. It is under my possession, that is the defendant. So the plaintiff wants the recovery of possession from me. So here, basic question, substantial question of law. That is a basic fact, your lordship. Substantial question of law is whether it is permissible to give the partition to only one individual without informing the others. So I have framed the substantial question of law, that is B is
Page.
page 3, your lordship. B, your lordship, up to the B. Whether issuance of separate patta in favor of one legal heir in respect of a part of land out of the
Was this the
joint
issue?
into family
Was there any
property.
counterclaim by you?
Yeah, that is the wrong, your lordship. That
There is no
they didn't
counterclaim.
have filed.
They had filed for declaration right title
Yes.
interest. You are going to
No.
another aspect.
Yes, it is admitted, your lordship. But my client has not filed a counterclaim. But only the question is whether it is permissible. Declaration of right title interest of the plaintiff. Whether the source of
When the order of 16/2/2016 is not the subject matter of challenge in any proceeding, thereafter, based on that, a suit has been decreed.
yes, it is there, your lordship.
Difficult.
But only my substantial question of law, can one person get the entire property of particular type by partition, by way of partition?
The partition was not even the subject matter of the suit.
Because that is the question, your lord. But it's a joint property. One get the partition,
Let us see the plaint.
your lordship.
Let us see the plaint, your
Plain.
corrected
Yes,
copy, how have you corrected?
Yes, that is very cleverly drafted, your lordship. At page 9, your lordship. The plaintiff is a resident of locality within the jurisdiction of honorable court. He is the brother of the defendant. Both the plaintiff and defendant are the citizen of India.
For declaration right title interest, there is no partition prayer.
Yes.
Difficult.
That there should be a counter claim.
You file a suit. So far as the order of 16/2/2016 is concerned, if it is permissible under the law. Third, Sri N. Upadhyay, Learned Counsel, for the appellant who has preferred this appeal under section 100 of the Code of Civil Procedure against a judgment and the judgment dated 14/12/2023 and decree dated 22/12/2023, passed by the learned additional district judge FTC, देख लीजिए हाँ, entitled appeal number so and so. Fourth stop, by the impugned judgment, comma, the first appellate court had confirmed the judgment dated 6/8/2019 and decree dated 19/8/2019, passed by the learned civil judge Lakhimpur, entitled suit number 10/2017. Full stop, para. It transpires that the suit, the learned counsel for the appellant has submitted that in the suit, comma, the present appellant was a defendant, which was instituted for declaration of right, title, and interest and recovery of possession. Full stop. It is submitted that the aforesaid relief was sought for on the basis of an order dated 16/2/2016, passed by the learned circle officer, by which the land in question was partitioned in favor of the plaintiff. Full stop. It is submitted that in the said proceeding before the learned circle officer, comma, no notice was issued to the appellant or the other siblings. Full stop, para. The learned counsel has accordingly proposed certain substantial questions of law
PCT.
substantial questions of law. Full stop, para. This court has, however, noticed that the proposed substantial question of law is on the aspect of partition, which was not even the subject matter of the suit. Full stop. This court has also noticed that there was no counterclaim by the appellant as defendant with regard to the separate patta that was issued in favor of the plaintiff. Full stop. Para. The findings under consideration being concurring findings and the substantial question of law sought to be formulated by the proposed by the appellant, not being connected with the subject matter of dispute which was adjudicated by the courts below, comma, this court is of the considered opinion that there is no substantial question of law to be decided by this court in exercise of its powers under section 100 of the CPC. Full stop. Appeal is accordingly dismissed. Yes. You file an independent suit, take it.
Your lordship may give the observation.
That we cannot. I dismissed. Yes, next. Yes.
Lord, our suit has been dismissed. Our suit for partition has been dismissed. One of the basic ground is that the suit was not maintainable because the other properties were not brought into the hotspot, and therefore partial partition would not be permissible. Those findings are at page 35, my lord.
So what is wrong with that finding?
My lord, there's a judgment by our High Court. It says that this concept of partial partition will not apply to the Dayabhaga school. Your lordship may just.
No, but how do you overcome the provisions of law in joining all the causes of action?
Lord, that could perhaps my second suit is barred under order to rule 2. That would come when I approach the court. But to say that the first suit is not even maintainable, I understand, my lord. Once I do not claim the whole of the property, later on I could be precluded under order to rule 2.
Yes, yes.
But the first suit at least should be.
Order 2, Rule 2, it's very clear. Until you join all the causes of action, you cannot file independent suit. Suit to include the whole claim.
Lord, the consequences.
You're
of-
the plaintiff.
I'm the plaintiff. If I may just face that judgment. Lord, here basically it was held that Mitaksara school, since the shares would keep fluctuating, a partial partition would not be proper. Lord, here the paragraph 3, the first substantial question of law was that which was formulated. And para 10 onwards, your lordship can sign the discharge.
Appellant is the plaintiff.
Yes.
Suit for?
Partition. Partition and also for declaring a revenue partition to be illegal.
Suit for partition. And what was the finding that all the properties were
It had
not?
not been joined, therefore.
No, otherwise you'll practically tell us if you do not join all the properties,
Hello.
how can there be an effective partition?
But there again, my lord, even for the Mitaksara school, now the Supreme Court has said that that is a little elastic. It may not be there.
No, but what to be partitioned? If you are not mentioning all the properties, can
Right.
there be an effective and equitable partition? How will
Right.
the shares be determined?
Well, I'd say, my lord, since we have a definite share, my lord, for the
Where?
same proportion would also apply to the remaining of the property.
Without
That is
that-
what this judgment is saying, my lord.
Where? Which judgment?
My lord, para 10 onward.
Please read.
Under Dayabhaga school, every adult co-parsoner who shares equally with others in inheritance in the estate of a common ancestor, male or female, has a right to call for and is entitled to enforce a partition of the co-parsonary property. And he has, even while the family remains undivided, a certain definite share in the joint property
Yes.
of which he is the absolute owner. To constitute a partition according to
This
Dayabhaga
has
law.
got nothing to do with the question which is confronting us.
My lord, the following paragraph.
Dayabhaga says that during your lifetime you can claim. Yes, why not?
My lord, and then, my
It is
lord,
not on the that, it is on the birds.
well, if I
Yes,
may just complete
yes.
the other paragraph.
Yes.
In the backdrop of the above contextual law on Dayabhaga school, there is no bar for getting the particular ancestral properties partition amongst the co-parsoner partly,
Yes.
the other property being left for partition for the time being. It
No.
is therefore held that after the death of the ancestor, the surviving heirs are entitled to get their ancestral land partitioned accordingly, their respective entitlement to the defined share even partly.
What were the facts?
Well, similar, my lord.
Let us see.
Well, finds these the properties at Kwalkusi were not included.
Let us see.
Para 3 onwards, my lord.
For the seconds. They does not want to press government to
Para 5 was the
That's what we are-
contention
the
raised.
ancestor cannot be partitioned partially.
I may read para 5, my lord.
Yes, please read.
Para 5, the contention to justify submission as regards substantial question of law number 1, as mentioned above, Mr. So-and-so has forcefully argued that the ancestral properties cannot be partitioned partially between the
How do
legal.
you overcome 2-2?
My lord. My lord, 2-2, I would say, my lord. 2-2, the bar would apply insofar as order 2, rule 2, sub rule 3, my lord.
Yes.
So therefore, my subsequent suit could be not maintainable, my lord. But to hold that
No,
because
if this is a defense taken
my lord,
by the respondent,
Hello.
by the defendant in the suit,
Hello.
it's not a question of a subsequent suit being.
Hello.
It's you have to include all the claims in the suit. If you do not, the suit is not maintainable.
my lord,
It's not qua a second suit.
if I may just read order 2, rule
Please
2.
read. Yes.
First is the general rule, my lord.
Yes, yes.
Sub-rule 1, every suit shall include the whole of the claim which the plaintiff is entitled to make in respect of the cause of action, but a plaintiff may relinquish may relinquish a portion of his claim in order to bring the suit within the jurisdiction of any court.
Yes.
Number 2, where a plaintiff omits to sue in respect of or intentionally relinquishes any portion of his claim, he shall not afterwards sue in respect of the portion so omitted or relinquished.
So-
Then sub-rule 3, my
Yes.
lord, a person entitled to more than one relief in respect of the same cause of action may sue for all or any of such relief, but if he omits except with the leave of the court to sue for all such relief, he shall not afterwards sue for any relief so omitted. So what the property that I omit to include, my lord,
Yes.
for that, if I come later on with a second suit, that would be barred, my lord. But to say that the first suit itself will not be maintainable,
But what about the substantial part, the number 1?
my lord.
Every suit shall include the whole of the claim
Correct,
which the
correct,
plaintiff is
correct.
entitled to make in respect.
Yes.
Have you made a statement that you are relinquishing?
I've not made that.
Then,
No, my lord, the consequence of non-compliance in sub-rule 1 is
Yeah.
sub-rule 2 and 3, my lord. That is what I've understood, my lord.
no,
Because-
then if suppose you are successful in your endeavor
My
here and ultimately,
My lord.
then you'll be precluded from filing any
As
suit.
and when I lodge a claim for the remaining properties, then the court will take note of this, my lord. But going by what our High Court single bench has said, my lord, that I
No, that's two was not even taken into consideration.
True, my lord. But this requires a consideration because ultimately the reasoning offered is that concept was introduced because the shares in Mitaksara would keep fluctuating, and that is not the case in our
No,
retail.
no, the discussion
Hello.
in the case of Nilima Bodua,
My lord.
that was, we do not have any manner of disagreement. That is correct, that what is the concept of Dayabhaga, on your birds you have the right, not like Mitaksara, that till the death. And you can at the time, even during the survival of the your predecessor or the other members, you can still
True.
pray for a division of the co-portionary property.
And with
First-
that analogy, subsequently they conclude at para 13, so therefore this concept would not be applicable.
No, we are on a different footing altogether regarding the other co-portionary property which are not the subject matter of the suit. Excluding that, will the suit be maintainable? Where are the findings? What was the issue?
Page 35, my lord. There was no issue on maintainability, my lord.
Why was it dismissed then?
But that was taken as a ground for dismissal. Page
Let us see.
35, my lord.
3-5.
35. This is the trial court finding.
3-5, yes.
Para 34, my lord. The authorities were discussed, my lord. Now, in the light of the aforesaid decision as to partition of property of a joint Hindu family, making it amply clear that a suit for partial partition without inclusion of other joint family property is not permissible under the law, the instance suit filed by the plaintiff is considered. It appears that in para 7 as reproduced here above, from the plaintiff it has been specifically pleaded by the plaintiff that the properties left by Surendranath Sharma in patta number so and so, under district Nagaon are not the subject matter of the instance suit. Further, from the cross-examination of the PW1, Hemkanta Sharma, it also appears that he categorically admitted that the plaintiffs have not sought partition in respect of the properties of patta number 68 and 257 belonging to the predecessors Surendranath Sharma, and that it is only in respect of the property of patta number 321 that the partial partition has been sought. Situated so, I am constrained to hold that the instance suit filed by the plaintiff seeking partition of a portion of the joint family property, admittedly leaving aside the other joint family property, is not maintainable, and an effective decree for partition in respect of a particular portion of the joint family property left by predecessor of the plaintiff and defendant cannot be passed as sought for by the plaintiff. This is more so when there is no evidence to the effect that a formal partition has already taken place in respect of the properties left out in the present suit. Consequently, in my considered opinion, plaintiffs are not entitled to the relief as claimed in the instance suit. Lord, another aspect, if I may just quickly point out.
But the relief which are concerning in this suit is the relief of partition. It is not other relief. Now, even if you are precluded from filing any suit for partition, you may not lose your right to have your share. So if you do not include those properties in the suit which you have filed,
My lord, the
how will
re-
that be?
my lord, the
And
cost-
the court has also taken into consideration the decisions in this aspect of the Honorable Supreme Court.
And those very decisions have been held to be not applicable in the judgment that I cited, my lord. That they since they relate to Mitaksara school, those judgments, my lord, 12 of that judgment by Justice Toikya, my lord.
No, with greatest of respect, the division, the concept of Mitakshara Dayabhaga will not come in this manner.
No, I understand, my lord. Your
It is on a-
lordship is
it is on a different
indicating for
footing.
an equitable division, all properties have to come, my lord. That proposition.
And this, if you come to 34,
Hello.
page 34, paragraph 33,
Hello.
the discussion of the Honorable Supreme Court in the case of 1994 4 SCC 294, please read this.
Yes.
Even otherwise, a suit for partial partition in absence of an inclusion of other family properties and implement of other courts are not warranted in law.
True, true, true.
This is nothing to do with Mitakshara or Dayabhaga.
Yes, my lord, but that the our High Court had said, my lord, and there is another judgment recent, my lord, which says that this is not an inflexible rule, my lord. Now, my lord, another aspect, my lord, actually two written statements were filed, my lord. We filed one was misplaced, my lord. But in that written statement, even in the judgment, this plea of maintainability appears from the judgment was not taken. Now, if this plea is not taken, my lord, I lose a right to correct my, if it was brought, it was pointed out at the very beginning, I could have included those properties in that whole one.
And let us see the issues.
Issues, my lord, will find at page 14. Page 29, my lord.
There is no issue on maintainability.
There's no
So-
issue in maintenance.
So where is the predicament you are suffering?
But it has eventually been held to be not
Let
maintainable.
us see what is the.
Page 35, my lord. And so also the appellate court had held in similar lines. You know. Now, had they framed an issue on maintainability, I could have.
But this is something which is whereby the provisions of law has been taken into. There is no specific mention of order two, but
Now,
Right.
why I say, my lord, if it were a pure question of law, my lord, then probably it can be decided at any stage. My lord, here, if the facts would have, I would have had an opportunity of bringing in the facts, my lord, I could have probably made out a case of exception as per the recent Supreme Court judgment.
which para?
10.
Yes.
This is a state of pleading and evidence in support of the existence of the property other than what has been scheduled by the plaintiff and for which partition is sought. It is true that the law looks with disfavor upon properties being partitioned partially. The principle that there cannot be a partial partition is not an absolute one. It admits of exceptions. In Main's Treatise of Hindu Law and Usage 17 edition, paragraph 487 reads as follows. Partition suit should embrace all property. Every suit for a partition should ordinarily embrace all the joint properties. But this is not an inelastic rule, which admits circumstances of a particular case or the interest of justice so required. Such a suit, however, may be confined to a division of property which is available at the time for an actual division and not merely for a division of status. Ordinarily, a suit for partial partition does not lie. but the suit for partial partition will lie when the portion omitted is not in the possession of the co-partioner and may consequently be deemed not to be really available for partition, as
Okay.
for instance, where part of the family property is in possession of a mortgagee or a lessee or is an impartible zamindari or held jointly with strangers to the family who have no interest in the family partition. So also partial partition by suit is allowed where different portions of property lie in different jurisdictions or out of British India, when an item of property is not admitted by all properties to the suit to be the joint property, and it is contended by some of them that it belongs to an outsider, then a suit for partition of joint property excluding such item does not become legally incompetent of any rule against partial partition. In the fact, well, these are had there been an issue, my lord, I could have probably said that I fall under these exceptions because one among those
Now,
properties.
you tell us now where the other properties encumbered or
One is an annual patna land, my lord, and the cause of action basically arose for this, my lord. 321 is the suit patna, my lord. It had close to 3 bighas of land. During the evidence, it has come out that all three brothers were occupying that particular portion for residential purposes, my lord.
Mm.
Now, my lord, one of the brothers, my lord, he went and got a revenue partition done for that particular patta, and he took out nearly 2 bighas, whereas 2/3 was our share. So the cause of action was basically because of that illegal revenue partition that he had carved out. My lord. So therefore, we had made a statement that there are more ancestral properties, but as of now, this is the subject of dispute, and therefore, page 13 is where we had candidly disclosed that there are other properties, but insofar as the suit is concerned, we are concerned only with 321. Now, 321 is
no,
the
if the
contentious part.
suit had been for a declaration that the action taken in the for one of the brothers has to be declared as
Yes,
illegal,
yes, there's a prayer.
inoperative.
There's a
But your suit is for partition.
no, that prayer is also there. Your lordship will see the prayer. Page 17. Now, because again, it amounts to approbating and reprobating in the sense that if
17.
17, my lord. Prayer number C. C and D. My lord. I'm sorry, D.
Mm.
At page 18. Now, my lord, this partition is affirmed by the court. Now, this is also a partial partition of sorts, my lord. If a partial partition is affirmed insofar as the defendant is concerned, to deny me a partition,
No, that is not a partition by the court.
true, my lord, that's a revenue
The
partition.
review partition, it came to the court as a way of appeal. The court was not adjudicating a partition.
My lord.
The first authority was it's a revenue partition. There's a difference.
No.
If
No,
you
no.
are seeking a partition through the court, it has to be done in accordance with law.
I bow down to that proposition, my lord. But again, our High Court has also said, my lord, in these cases, my lord, revenue partition also should not come in the way of a suit, because ultimately, going by the executive instructions formulated under the rules, there has to be a consent of all the co-sharers.
Okay.
Right.
Or Sri B.D. Decker Learned Counsel for the appellants who by means, please address it, who by means of this appeal filed preferred under section 100 of the Code of Civil Procedure has assailed the judgment and decree dated so and so, cost title of page 2, Roma Diaz. Full stop. It is submitted that the cause of action in the espoused in the suit was not only confined to a partition, to a degree of partition, but had also challenged the revenue partition, which was made earlier in favor of the defendant number
1.
of the defendant. Full stop. As regards the provisions of Order to Rule 2, comma, the learned counsel for the petitioner has submitted that the restrictions may come into operation only in case of a subsequent suit and may not be an absolute bar for adjudication of the suit of the present nature. Full stop. The learned counsel has also relied upon the case of the Honorable Supreme Court in B.R. Patil versus Tulsa Sailaba, so and so, reported in so and so, wherein the Honorable Supreme Court, after by referring to the Maynes, M-A-Y-N-E-S, apostrophe, Treatise on Hindu Law and Uses, 17th edition, had made certain observation on the said aspect. Full stop. Para. The portion of the aforesaid treatise which has been quoted in paragraph 10 of the aforesaid judgment would, however, clearly show that the exception to the rule that a partition suit should embrace all properties are on certain eventualities, which eventualities only. Full stop. Para. Be that as it may, comma, the appeal is admitted on the following substantial question of law. No, it is further submitted that without there being a specific issue on the maintainability of the suit, comma, the dismissal of the suit on the maintainability ground has caused prejudice to the appellant plaintiff as appellant plaintiff. Full stop. Para. Be that as it may, comma, be that as it may, the appeal is admitted on the following substantial question of law. Number 1 to the any other? Yes, who are the respondents? How many respondents?
No, it's just one.
Apex
This is
Bank.
a pro forma.
Okay. Let steps be taken for service of notice upon the respondents, including the pro forma respondent, by usual process. Steps within 3 days. It would possible, B.R. Patil.
May I please? In this case, the sole respondent as plaintiff has instituted a suit.
Appellant is the defendant.
Stating that the suitland
Suit for?
Suit for, my lord, recovery of khas possession and issuance of permanent injunction preventing the defendant from entering the suit.
Khas possession and injunction. Okay.
And the counterclaim was filed.
You filed counterclaim?
Yeah.
For
my lord, similar, almost similar, the preventing the plaintiff from
injunction,
this year and
confirmation, confirmation of position.
confirmation of the counterclaim dismissed. Plaintiff suit was decreed. Preferred appeal. The judgment of the trial court was upheld. The basic ground, my lord, I had
The appeal was both on the counterclaim as well as the
both
suit.
the counterclaim dismissed.
No, your appeal.
Yes.
You had filed appeal against the dismissal of the counterclaim or against the decreeing of the suit.
Against the decree of this.
Suit.
The whereas appeal was not for
Oh.
dismissing the count.
Okay. Appeal.
So now, my lord, both the trial court as well as the appellate court has decided the suit on the ground. Your lordship kindly, because I have prepared the only on the ground that the name of the plaintiff found to be appeared in the revenue record, and that is Jamabandi. This is the main ground. First, your lordship kindly peruse the page 44. What is the case of the plaintiff?
See, this was not a case for declaration of right title and interest.
No.
So you'll be, perhaps you'll not be correct in submitting, if you do also, that on the basis of the Jamabandi, the decree could not have, decree is only for recovery of possession.
It is there, man. But what is decided, my lord? Your lordship kindly peruse.
Page
Trial court judge order, my lord, page 32 relevant portion.
32. 32.
32.
Yes, please. Yes,
From last paragraph, man.
yes,
Whether the issue number 3,
yes.
the plaintiff got right title over the suit land and mutation of plaintiff is legal or not. The plaintiff thoroughly examined himself as PW1 and also examined Narabahadur Baskoti as 2 and Suran as 3. The plaintiff in his evidence stated that Baskotia was the original owner of the suit land, which was an annual patta land, and delivered him possession over land measuring 11 vigas, 4 kata and 15 lesa. The plaintiff further stated that he was possessing this entire land till he was dispossessed by the defendant on such and such. The plaintiff is regularly paying land revenue. Later on, the land was converted into Miadi Patta land, and he became recorded Pattadar in respect of the scheduled land. The plaintiff further stated that on the date of disposition, he lodged an azhar with the police outpost. After investigation, submitted non-FIR case number such and such under such and such. The learned executive magistrate, after hearing the parties, passed an order in favor of the plaintiff, but the possession remained with the defendant. Hence, the plaintiff filed this suit for declaration of his right title and interest and eviction of the defendant. Plaintiff also proved a copy of Jamabandi of the suit land, which is covered by Patta number such and such, measuring an area of such and such. Further, the plaintiff also proved the land revenue receipt and also proved the copy of the judgment and order of learned executive. The copy of the Jamabandi shows that the plaintiff became the recorded Pattadar and his name has been included in the Jamabandi by deleting the name of the original owner, Narabahadur Baskotia Chetri. Also, PW2 also corroborated the evidence of plaintiff. He stated that he was the original owner in respect of annual patta land, which he sold to plaintiff after the land has been converted into Miadi Patta. The plaintiff became the owner of the land and possessed the same till he was dispossessed. PW3 also supported the evidence of the plaintiff and stated that he has land adjacent to the land of the plaintiff. On the other hand, the defendant examined full number of witnesses and claimed that the mutation of the plaintiff is illegal and that the entire land was owned and possessed by late Joy Bahadur Baskotia, father of Narabahadur Baskotia. Further, DW1 Kitabali stated that The disputed land originally belonged to late Joy Bahadur Baskotia and he sold the land to Jogram Soikia and Padmeshwar Soikia by executing registered deed. He proved both go and go and further submitted that the original owner, Joy Bahadur Baskotia, executed 2 registered deeds by handing over possession to Joyram Soikia and Padmeshwar Soikia in respect of the land measuring such and such and such in favor of Majar Ali, who gifted the land measuring 5 biga 3 kata and 17.5 lesser to his daughter Joveda Khatun, marked as Exhibit 2. Further, DW1 stated that Majar Ali on the same date handed over possession of land measuring 5 biga 3 kata such and such to Kitab Ali by executing Exhibit Joe. All these documents are executed in favor of the defendant by late Joy Bahadur Baskotia, who claimed to be the original owner of the suit land. But the defendant have failed to bring any document to show that Joy Bahadur Baskotia is the original owner of the disputed land. The defendant claimed that late Joy Bahadur Baskotia was the exclusive owner of the land, and after executing Exhibit O and Go, no land was let to be inherited by Nara Bahadur Baskotia. Hence, the claim of the defendant cannot be accepted. On the other hand, the plaintiff has proved the Jamabandi, which shows that Nara Bahadur Baskotia was the recorded partner of the land, and the revenue authority, after conversion of land, recorded the same in the name of the plaintiff. Further, the land revenue receipt as well as the judgment of land and executive measure also support the claim of the plaintiff. Admittedly, there is no sale deed in favor of the defendant, and only 3 deeds of agreement are proved by the defendant's side, which does not confer them title automatically.
Mr. Udin, is there any finding regarding the title?
It is said that better title.
No, better title is not a
Better
title.
title.
Better
No,
title is
this
the
is not a
expression
case
used.
of title. This is my
No,
case is that
how have you framed
I
your-
have prepared, my lord. Your lordship, for a moment, kindly see page 4. I have prepared
that is the exactly question we are trying
first
to
on the ground of, my lord,
title.
mutation. Next, my lord, perversity. Perversity to the effect that court has said we have not produced any document, proved any document, but the judgment itself shows that 3 documents we have exhibited.
What are those 3 documents?
Your lordship, kindly page 34. Once again, my lord.
Yes, what are those 3 documents?
Go,
What are those?
Joe and Joe, 4 documents.
What are those?
Those, my lord, Go and Go is the document that, my lord, the land, admittedly, the land was, my lord, annual patta land at that time.
No, it was converted.
Subsequently, according to plaintiff, in between, my lord, 2007 or 2006, it was converted into Myadi patta in the name of original annual patta holder.
Yes.
And he has handed over, but there is no document at all, my lord, he has proved. Only this is the evidence, only relying upon the oral evidence. But we have said, your lordship, kindly for a moment once again, my lord, originally belonged to Joy Bahadur Baskotia,
Yes.
and sold the land to Jugiram Soikia and Padmeshwar Soikia. Joy Bahadur Baskotia sold this land when it was annual patta land. So obviously it will be an agreement, my lord, because there is no sale deed. So it was in the name of Soikia by executing registered deed. This deed was exhibited, my lord. He proved both Ho and Go, these 2 deeds, that Jugiram Soikia and Padmeshwar Soikia, these 2 deeds has been, my lord, exhibited. But that way are not the holding that these are the only agreement. These were not considered. So on that ground, my humble son, there is a perversity.
Now, who are you?
I am, my lord, out of 11 biga, the total land in the patta is 11 biga 4 kata, but the disputed land is 4 biga. We are the, my lord, holding possession.
From whom?
4 biga of the land.
From whom?
That we have stated, my lord. Our case, your lordship will find.
What was the strength?
Page 56.
Page 56.
That
Under what strength did you enter or take possession of the land?
Yes, page 56, your lordship.
Yes, please read.
Page 56. paragraph 9 or not.
Yes, please.
That in fact the Suitland was originally belonged to Joy Bahadur Baskotia Chetri, the father of Nor Bahadur Baskotia Chetri, which was his self-acquired land. The
Yes.
state Joy Bahadur Chetri sold the land to Jaguram Shoikia and Padmeshwar Shoikia by executing a registered sale deed by its deed number such and such, dated such and such.
Okay.
Thereafter, on such and such, he sold the Suitland to Konakeshwar Bora and Paniram Bora by executing a registered deed by registered deed number such and such.
Hmm.
Thus, no share remain in the Suitland in the name of Nor Bahadur Baskotia.
Yes.
Specific case, my lord. The defendant to prove the contention would buttress upon the sale deed by exhibit such and such. Go and go.
Hmm.
Thereafter, the disputed land was muted in the name of state purchaser Konakeshwar Bora, Paniram Bora, Jaguram Shoikia, and Padmeshwar Shoikia, and record was corrected accordingly.
Yes.
Exhibit Ungo is the said chita. Thereafter, on such and such, Jaguram Shoikia and Padmeshwar Shoikia sold the entire plot of land measuring 11 biga 4 kata 15 lesa, including the Suitland to Mazhar Ali, son of late such and such, and handed over the possession to him. The defendant relied upon exhibit show. The original copy of the said exhibit was submitted in the aforementioned mistake number.
This transaction, on 7/4/1982,
Yeah.
by which Jaguram Saikia and Padmeshwar Saikia had sold the entire plot of land to one Mazhar Ali. This is by what?
Exhibit go.
Now, what
No.
was the deed?
Exhibit show.
Now, what was it? Registered sale deed?
That, yes, my lord.
Where have you stated?
Because the original copy is with the record, my lord. Record will reveal.
No, what have you stated? Nothing. How was this transfer done?
The defendant relied upon exhibit show. The original copy of the said exhibit was submitted in the aforementioned case. That means the in miscellaneous case under 144 that was submitted. So record of that case will reveal only, my lord. That was not called for. My instruction, as per my instruction. So on the basis of only perversity, that may appeal may be, my lord, Hamal submission, my lord, at this stage may be admitted, my lord.
How you are sons of Mazhar Ali?
No. Letter part will, my lord, paragraph 12 will, my lord. Thereafter, on 92, Mazhar Ali handed over executing a kacha deed, handed over possession over a plot of land measuring half of the land, my lord, out of 11/4/15 lesa, his daughter, wife of Hassan Ali, to reside over constructing dwelling house.
What was this gift deed or what?
That is only a gift deed, my lord, to his daughter, Juveda. This is exhibit show, said kacha deed. On the same day, paragraph 13, how we come, my lord. On the same day, Mazhar Ali was in need of money for his treatment, sold remaining plot of land measuring, that is half of the remaining half, out of total 11 4 kata 15 lesa, covered by DAG number 14 annual pattern number 28, including the Suitland to defendant Kitab Ali, and handed over the possession over the said plot of land. Exhibit J is that document. So by way of purchase, we have come. So these documents are apparently not considered in a proper manner. So may I at this stage pay my lord on the ground of perversity that appeal may
No,
be
no,
admitted?
See, your own pleadings at paragraph 13, please read again.
My lord.
Remaining plot was sold by Mazhar Ali as he was in need of money, that half portion to you. Now see the description of total land of illness covered by DAG number 41 annual patta.
Yes. All the, that I have already submitted, my lord. Only in 2000, sometime in 2006-7, that land was converted into periodic patta. Prior to that, the land was annual patta.
It was an annual patta land.
Yeah.
So only at best the possession could have been sold or transferred.
Yeah.
Nothing beyond that.
That is our case. Our case is that they said Nor Bahadur Baskotia has sold this. Plaintiff case is that Nor Bahadur Baskotia sold the land to plaintiff.
Okay,
And our case is Nora Bahadur's father,
okay, we'll come back at 2 o'clock.
my,
Suit was only for recovery of possession,
No.
not for declaration.
not for-
Okay, let us see.
Let-
Oh, yes. No, no, no.
Lordship, I beg to mention item number 28. There is small correction in the order first item. Let me before I
Before,
maybe-
let us see. There is one matter which is fixed off an outlying bench. We'll have that, then we'll take up your matter.
of like.
May I please, my lord.
Yes,
My lord, I appear on behalf of DHJM Kathong, my lord.
yes.
My lord, due to some personal difficulties, he is out of station. The matter may be adjourned for
You
the
have
day.
listed on
Next-
your
next
behest
meeting.
by making a special mention and you are taking time. What is this?
Brother, due to his son admission.
No, that is
Is
okay.
out
You
of
should have fixed on another date as per your convenience.
Yes, my lord.
We have this matter out of turn.
My lord, matter may
21.
be fixed 20 of this month.
21,
20 of this month.
23rd.
my lord.
Could it be 20, my lord?
You're for whom, Mr. Rafa?
I'm for the.
2020.
From 5 to 65.
You're praying for which date? You're praying for which date?
20.
20.
20.
Thursday.
That is my
Thursday. Thursday. Okay, Thursday at 2 o'clock. At 2 p.m. Okay. What is your name?
M. Sora.
Your name?
M. Sora.
M. Sora.
N. Sora.
N. Sora.
Yes, my
Okay.
lord.
Though this case has been listed on a special mention made by the Learned Council stationed at Itanagar, as the same relates to a prayer for review of an order passed by this court, comma, 3 N. Sora, no? N. Sora Learned Council has, however, prayed for an adjournment on behalf of 3 M. Kato, Learned CGC, full stop, para. Also heard 3 M. Kato, who has appeared online. Also heard 3 S.R. Rabha Learned Council for the respondents.
It's on number
Opposite parties.
Yeah.
Opposite party numbers
5 to 65.
5 to 65.
Private.
Para. In the interest of justice, comma, matter is adjourned to be listed, adjourned, and on request it is listed on, let it be listed on 20 করে না? 26 2024 at 2 p.m. 2 p.m.
Okay, my lord. Deeply obliged.
Now the observation made by the court regarding better title is based on what? You say that
That
you
is
had,
not, my humble submission is that much. This is not suffice. Because the claim of the plaintiff is that, the case of the plaintiff is that he has right title and interest over the land and has been dispossessed by the defendant. Therefore, based on title, he has claimed for recovery of khasut. And it is the settled law, this Honorable Apex Court has held that when any possession sought to be recovered based on title, the court first decide whether the plaintiff has his title. That has not been decided. Only revenue record, that cannot be, my lord. I am relying on the judgment of this Apex Court, my lord. I will place it at a later stage. Here the another, my lord, there is a, my lord, a great, my lord, procedural error has been.
let us see the plaint.
before my lord, a procedural
No, no, there is city plaint.
plaint is my lord, page 42.
Four two.
Relevant page is 42. It starts from yes, it starts from 42.
They have only prayed for recovery of caste position. They have not
Yes.
prayed for declaration.
My my case submission is that when a prayer is made for recovery of caste position,
Yes.
it may be either based on title or based on continuous position.
Yes.
So here his case is that he is the right title and right title holder of the interest holder of the.
No, he's not seeking a declaration on that aspect.
No. Yeah. My humble submission is the plaintiff case is he is the owner of the land and the defendant disposes him. Therefore, he paid. So the case is based on title. So the trial court as well as the first appellate court ought to have decided whether he had title over the property.
That may be your interpretation. Unless he is praying for a declaration of right title interest.
I am relying upon a judgment, man.
No, unless he is asking for a declaration, he has taken the risk. He is not asking for a declaration of right title.
These are my
He is only
connected things.
No, connected. Possession may not be essentially on right title interest. Your tenant is also in possession.
When a person asserts the fact that I am the real owner of the particular property and I have been dispossessed from this property, first I have to establish that I am the owner of it. If it
And
is proved,
in your counterclaim, you also only prayed for injunction. You did not pray for.
yes, we have said it is our property. So there is therefore counterclaim part. We have, it is already your lordship, I have led to your lordship
So
to the pleadings.
the contention which you are raising will be counterproductive.
Yes.
You say that since his claim is based on certain title, without proving that title, it could not have been granted. Same will be applicable to you.
Yes.
You say that
Yes.
your the property in question was purchased by you on 27/1992
Ma'am.
by a deed. Pacha deed by Mozor to daughter, one part, then another deed to you.
Yes.
Remaining plot sold to you.
This issue has been framed, how it is dealt with, my only one preka. On my counterclaim, trial court, the issue, your lordship, that is my lord relevant. Your lordship kindly once
Issues,
again,
page issues.
once again come to the my lord. Trial court judgment, page 32.
3-2.
32. 32 and my 35.
Yes.
How it is only one breaker. Whether counterclaim claimants are entitled for right over the suit land by possession. The defendant in their counterclaim claim that they became owner of the suit land by virtue of the exhibit Ko, Ho, and Go. Further, they claim that after the execution of exhibit Ho and Go by Jai Bahadur.
See, you have three exhibits in your favor: Ko, Ho,
Go.
and Go. And what is their basis of claiming? Plaintiffs?
Entry of their name in the Jamabandi and paying continuous revenue.
Entry in Jamabandi presupposes possession.
So that cannot be. Another, my lord, procedural aspect I have found, my lord, here. It is a procedural error in this case.
What is it?
Counterclaim dismissed, plaintiff suit was decreed. So as per procedure, separate appeal ought to have been filed. But a common appeal file, kindly peruse my memorandum of appeal. That has been error committed by the council. In memorandum of appeal, prayers for both, my. It is a common appeal, appears to. And appellate court judgments also appears, my lord. They have, your lordship kindly peruse first, my lord, memorandum of appeal.
Just a minute, please.
Page 78.
Just a minute.
Page 78. I got it. In the
Now,
matter of an
what about order 41 rule 22?
in the matter of an appeal
So
as
this-
per order 41 rule 1, 2, 3, 4, 5.
Now, what about order 41 rule 22?
Re-hearing on application of
No,
respondent
no, order 41, rule 22, not
On-
16.
upon hearing
Yes.
Upon hearing, respondent may object to decree as if he had preferred a separate appeal. Here, judgment, your lordship kindly bear that okay, but judgment of the appellate, both the issue has been framed. That it appears that a common order on my appellate court has framed both the issues. For a moment, kindly peruse the appellate court judgment. Page 14, issues
1-4.
1, 4,
Yes.
3 and 4. Page 14, paragraph 6, Roman 3 and 4. 3, the plaintiff's claim, the 4, whether counterclaim are entitled to right over suitland by.
But the first question which you have formulated regarding decision on title, where is the decision on title? There is no decision on title.
Decision of that may be typographical mistake.
No, you have sent title. You just see page 4 as to whether the learned trial court as well as appellate court was correct in deciding title. Title was not decided.
In deciding, in decreeing suit, typographical mistake.
In decreeing suit is deciding title. That is not typographical error.
And next is, my lord. 3 and 4, my lord, I am paying for.
3 is absolutely, it's a vague question.
And ko, go, ungo, cho, and cho. These are the exhibits. Not at all taken into consideration. Why this has been discarded. So perversity is there.
Difficult. Now who's in position?
We are in.
You're in position. Suit was of which year?
It is originally in the year 2016.
16.
Subsequently, it has transferred to civil Munshi in 20.
Heard Sri A. Iodine, learned counsel for the appellants who has preferred this appeal under section 100 of the Code of Civil Procedure against a judgment and decree dated. Cost Para. The appellants were the defendants in the suit filed for, instituted for recovery of khas possession and injunction. Full stop. The appellant's defendants had also made a counterclaim for injunction and confirmation of possession. Full stop. Both the suit and the first appeal preferred by the appellants have been dismissed. Full stop. It is submitted that though the documents by which the title of the land in question was transferred to the defendants were duly proved, the same were not taken into consideration in its proper perspective by both the courts below. Full stop. Para. The appeal is admitted on the following substantial question of law. 4 to the Bakul, page 5, all 4, single ho, any other. Last steps for service of notice upon the sole respondent be taken by usual process. Steps within 2 days from today.
I am obliged.
Rest after 6 along with.
IA
Execution has been started.
Not yet, my lord.
You press it when
I am aware.
it is kept open.
Wait, please, your lord. The decree against reversal, my lord. I'm the plaintiff, the appellant is the plaintiff, my lord.
Okay, just a minute, please.
My lord.
Appellant is the plaintiff.
My lord, our plaintiff.
Suit for
So, for my lord, recovery of money, my lord.
money suit.
Money suit, my lord.
Decreed.
Decreed, my lord, in favor of the appellant.
Appellate court reversed.
Reverse it, my lord.
Yes.
My lord, a substantial question of law at page 9, my lord.
Page 9.
Page 9.
They had taken the defense of Assam Moneylenders Act.
My lord.
They had taken the
They had
defense.
taken.
Well, how have you framed this substantial question of law?
Because, my lord, there is no finding by the, my lord, appellate court that we are money lender under the purview of the definition of money lender, my lord, in that act, my lord.
Under the 1934 Act.
My lord, there is no finding that there was no finding, my lord, by appellate court, my lord. We fall within the purview, my lord. There were two transactions only, my lord. And nothing on record to show, my lord, that we are.
Is has the appeal been allowed only on this point?
Yes, my lord.
That the suit was barred?
Only on this point, my lord.
You are not registered under the Assam Moneylenders Act
Yes, my lord.
1934?
Yes, my lord. Only on this point, my
lord. This point was taken in the defense?
My lord, not exactly, my lord, but in WS, they are taking consistent pleas, my lord. Once they have said that, my lord, this amount was, my lord, paid to the appellant, my lord, in pursuance of transaction of, my lord, sale of textile. Then again they took another plea, my lord, that since he is not registered under the Assam Money Lending Act, my lord, he cannot claim this thing.
That has been taken, but they can take wavering stand.
My lord.
Defendant is entitled to take wavering stand.
My lord.
Plaintiff cannot.
My lord.
So if that point has been taken into consideration,
my lord.
And if you are not registered under the Act of 1934,
My lord.
then the bar will come into operation.
Definitely, but my lord, thing is that, my lord, there is nothing on record in the evidence also.
But was it a loan or what?
It is a loan, my
loan.
But, my lord, apart from that loan, my lord, there are no other transactions. I have been doing business. I have been tendering loan to others. I have given loan to this.
You are contending that is not your business.
No, my lord, it is not my business.
It is this solitary incident of.
My lord, that is my account, my lord.
Okay. Heard. R.S. Mishra, Learned Counsel for the appellants who, by means of this appeal, preferred under Section 100 of the Code of Civil Procedure 1908, has assailed the judgment and decree dated so and so, The please have your seat. The appellants were the plaintiffs in the suit instituted for recovery of money. Full stop. The suit was decreed by the trial court, which, however, was reversed by the first appellate court. Full stop, para. It is contended that the invocation of the Assam Money Lenders Act 1934 was uncalled for, as it was not the business of the plaintiff appellant to give loan, and it was a solitary incident wherein the loan was taken by the defendants respondents. Full stop para. Let the appeal be admitted on the following substantial question of law. Whether the transaction of rupees 3 lakhs
My lord, relax.
between the predecessor in interest of the appellants and the respondents would come within the definition of loan under the Assam Moneylenders Act 1934, and therefore whether the suit would be barred under the said act. Full stop. Any other questions? Huh? Let notice be issued for service of notice of let steps be taken for service of notice upon the respondents by usual process, steps within 2 days. List after 6 weeks along with report on service LCR. Huh? Admit on the
DP of
on the substantive question, call for the LCR. I go to the Marise, call for the LCR. Yes, okay.
Obliging.
It is the appeal by the defendant. The judgment shows that it is a judgment of affirmation, but in fact, it is a judgment of. But if you take out history, whether it has got.
Appellant is the defendant.
Appellant is the defendant.
Suit
Well,
for?
But I have given.
Suit for?
Suit for, right interest and recovery of. Initially, suit was decreed in 2000. Well, your lordship can see the list of dates in additional appeal. It is a checkered history in the sense.
2000 suit was decreed.
Then the defendant appealed. In the appellate court, set aside the judgment and remanded the matter back to the trial court to see whether the trial court has the pecuniary jurisdiction. Upon remand, the trial court held that it has no pecuniary jurisdiction and therefore dismissed it. My lord, against that the plaintiff appeal, that is the appeal number 7 of 2004. Appellate court also dismissed the appeal, holding that the trial court has done the same. Instead of going into the question of Order 7, Rule 10, then the plaintiff further appealed to the High Court, Honorable High Court. Your Lordship, please to see then the High Court order.
RSA,
my lord, it is in the main memo of appeal.
appeal was, plaint was dismissed or returned.
No, it was not returned. That's why it was held by the High Court that whatever the trial court has committed mistake, it was the same thing by the appellate court. Therefore, the matter was remanded to the appellate court to decide the appeal number 7 of 2004, which arises out of the dismissal of the appeal, dismissal of the suit on the ground of pecuniary jurisdiction. That is decided herein. But your Lordship, please to see at page in the memo of appeal, at page, my lord, 60 or 61.
The appellate court's the judgment which is impugned in this appeal is on the merits of the suit or on the ground,
Merits.
on the entire merits.
Therefore, this is not going to help me other because of section 99 of the CP. But my lord, I am deciding it, I am showing it only for the purpose of showing that it is not a judgment of affirmation. It is a judgment of record. In the sense that it was this appeal number 7 of 2004 by the plaintiff itself, which was decided. Plaintiff suit was decreed here. Now, your lordship, please to see the judgment is at page 'The plaintiff's case is that their forefather had purchased the land and thereafter they are possessing it. But the defendant have encroached upon the land on a particular date, that is in 94. And that's why the suit was filed, for the purpose of declaring the right to interest and for recovery of funds.
Yes.
Now, your lordship, how
How was the title proved?
title has been proved, my lord, at page 68.
68.
Page 68.
Yes.
The pleadings of the parties, page 68.
68.
The pleadings of the parties reveals that there is no dispute regarding the fact that the plaintiff has got title in respect of the suit property. This is a wrong reading of the, my lord, WS by us. Whatever has WS to the page. Your lordship, please to say page 14, para 14, at page 16.
You said it's a perverse finding. You had disputed the title in the WS.
If that, well, the WS has to be read, pleading has to be read as a whole. In one line, your lordship, please to see page 16.
Page?
Page 16.
16.
Para 14. The plaintiffs are not the owners of the land. They have got title, nor they possess the suit land at any point of time. My lord, this is a wrong. Paragraph 14.
Real facts.
Real fact. The plaintiffs are not the owners of the land.
Plaintiffs are not the owners. They have got
Title. Nor they possess, they have not got any title actually. Nor,
I think this is a
otherwise,
type-
nor does not come in.
This is a typographical error.
Typographical error. My lord, the learned court below has banked upon it to say that the title
They
in
have
respect
got
of the
title.
suit property.
Where is the original?
Original.
Madam,
Original.
Original.
No. We talked
They have got, yes, I have seen it.
Page
Page
20.
20, page 20. Page 20, you have got it. Okay, this, but is that the only, consideration, Mr. Das?
No, there are other considerations also.
So that is
Other
it.
consideration is Exhibit 10. Exhibit 10, in addition to it, Exhibit 10 was a decree, a judgment in decree of earlier suit between the parties. Between the parties means, my lord, the forefathers of the plaintiffs and the predecessor interest of the defendant. But that judgment foundation was not laid in the pleading. Your lordship, please to see the pleading plaintiff. Plaintiff also. Page 6, my lord. Page 6.
Yes.
Only they say paragraph number 1, page 7. Osimuddin Bepari, father of the plaintiff, is the actual bona fide owner. So which are most specifically mentioned in the schedule annexed, which he purchased from the lawful owners by registered sale deed, so and so, which he purchased. And that is your lordship is to the entire plain. Nothing is there. So to say that whether there was any sort of a title suit between the parties, it is on the basis of this sale deed, purchase deed, so to say, that the plaintiff banked upon their claim.
Okay.
But the learned appellate court also banked upon Exhibit 10, which was cited by PW6, namely a title suit in 75. At page 68, last line, but the evidence on record disclosed that the then Honorable Assistant District Judge, filed judgment dated so and so, passed in title appeal number 28 of 75, marked Exhibit 10, has already declared rightly interest over the suit land of the predecessor of the plaintiff, namely Osimuddin Bepari, against the aforementioned persons from whom the defendants are tracing their right, and that the judgment and decree has already attained finality. Now, if that be the position, then I am of the considered opinion that when the Khatiyandar through whom the defendant is claiming their right has no title over the suit land, then the question of the defendant's right over the suit land does not arise. Hence, in view of the matter, the title of the plaintiffs over the suit land by of inheritance is affirmed, and accordingly they are entitled to a decree of declaration of right and title and eviction of the defendant. That was a suit for injunction, and the injunction was refused by the trial court. That is the Exhibit 9. I have given it. But in Exhibit 10, that was a suit for injunction because the suit was dismissed on the ground that the plaintiff does not have possession of it. The appellate court held that he had possession over the land, therefore granted the decree of injunction. The question of right to interest does not come in. And there is no foundation of in the pleading. Therefore, I have framed the question. Round number 3, my lord. Question number 3. I've separately, my lord, I have tried to call out.
But don't you think that a judgment can be referred in support of the case? Maybe it's a judgment between the same parties, which was not mentioned in the as such in the plaint, and therefore you're rightly perhaps making a submission that there was no foundation of this evidence.
And I could not traverse it.
But isn't that a judgment? Is it a fact? Cannot it be distinguished between any other fact and a judgment passed by the court between the same parties? Had it been any other facts that you should have been given a scope to rebut or to traverse or whatever? Now this was put in the chief examination as an exhibit. You had cross-examined, and after all, it's a judgment.
No, cross-examined and he said, PW6, that we have not traversed anything in the plain regarding this document.
Now that is okay, but regarding the veracity of the judgment or authenticity, you had not doubted.
No, I am doubting it in the sense that that was a suit otherwise also. That was a suit for injunction.
By that title was not decided.
No. It cannot be so.
Do you have that exhibit?
Exhibit 9 and 10
10?
in additional appeal. কোথায়? কত page?
Page?
So, কোথায়? এটা কোথায়? পৃষ্ঠা কোথায়? 94, exhibit 9 and exhibit 10 is 95, 99.
This decree was in the title appeal stage
Hi, yes.
and the
Title-
suit was dismissed.
Suit was dismissed. That is exhibit 9.
Title appeal 23 or 28. What is this number?
Right.
Is it 23 or 28
5.
of 1975? At page 95, madam, please assist your senior. 28, not 23. Okay. 28.
20.
Yes, permanent injunction. Permanent injunction. You can, this is discernible at page 91. The trial court judgment.
Yes.
First paragraph, last line.
Yes.
So the plaintiff prays for permanent injunction, page 91.
Yes, but
91, the first paragraph. First paragraph, last line.
so the plaintiff pays for permanent injunction and decree with cost of the suit.
Only permanent injunction. Okay. So even if we ignore or overlook or your first submission that there was no foundation, even otherwise that
Yes.
we may not have too much of relevance
Yes.
in the adjudication of the present matter.
Present. Otherwise also,
Are these the only two aspects that there was no dispute regarding the title? Are these the only two aspects or any other consideration?
other considerations also, that exhibit 2, 3, 4 and 6, which I have annexed here with in additional document, which shows the name of the predecessor interest of the plaintiff along with other co-sharers. Therefore, whether he can claim a definite portion on those lands. That is the question number
But
one.
the other co-sharers are not the aggrieved parties.
No, they may not be agreed party. But whether in respect of the specific portion, he can have.
Was there a counterclaim by you?
No. There was no counter. Counterclaim means, my lord, if I have got some sort of.
That he did not, if you question is his title, there are other co-personers who was not, that aspect we may not go into. But see, this even that the assumption of the of the appellate court regarding title,
Yes.
Based on the pleadings, a wrong reading of the pleadings.
Yes.
As well as the exhibit 10, Apart from this, there are other considerations also we have seen.
Other considerations, my lord?
It is not incumbent on the appellate court or any court that it has to be on all the points. It can be on other points also.
No, it lordship is to see. Weakness of the plaintiff's case, defendant's case.
Yes.
That is one of the count. Judgment virtually finishes 68 to 70. 68, 69, 70. Adverse position, question of adverse position, I am not claiming because I cannot claim it. 68, 69, 70.
No, even if we hold your 3 and 4 to be substantial question, there are other considerations for allowing the appeal and decreeing the suit. The questions which you have framed,
yes,
formulated 3 and 4, we may deem this to be substantial question of law, which are substantial to the issues between the parties. That is
Yes.
the one. But even a decision on these two issues in your favor will not may not be enough to interfere with
the appellate judgment does not show any other thing. Your lordship is to say 69, 68, 69, and 70
of your okay.
of the memo of appeal. 68, 69, and 70. It discusses about the defendant's case and says the defendant's case is weak.
You are in possession now.
I am in possession.
How much is the suit land?
It's 8 bigha. No? 8 bigha tillage. How much?
Homestead. Homestead land or agriculture land?
Agriculture plus homestead. 8 bigha tillage. In 4 dak.
Okay. Why is under Order 41 Rule 11 and not for admission directly?
Order 41 Rule 11. That is the appeal has to be admitted by a lot.
That is it. No, this. Why is it not under the normal heading of admission?
Oh.
There is some weakness in your case or what?
No.
Yes.
Normally appeals are admitted on the ground or Order 41 apply in case of appeal.
No, understood, but
because the commander is there.
in the list, this is one of the exceptional cases under 41 Rule 11, where appeals are to be dismissed without sending notice. So does it indicate that we should go by the law and dismiss the appeal without issuing notice?
That can be also done. But if your lordship is satisfied.
Now we think that we'll admit this on 3 and 4.
Here.
No. We'll be accepting notice. We are admitting this. Okay. Heard BC Das, Learned Senior Counsel, assisted by MSS Roy for the appellants who has preferred this appeal under section 100 of the Code of Civil Procedure, assailing a judgment and decree dated so and so. हाँ यहाँ से देख लीजिए हाँ. Para, the Learned Senior Counsel has submitted that there is a checkered history of litigation, and the earlier round was on the aspect of pecuniary jurisdiction, which was finally settled by this court in an earlier appeal. Full stop. Para. While the matter was remanded to the first appellate court, comma, the appeal has been allowed and the suit has been decreed. Full stop. Para. Admit the appeal on the following substantial questions of law.
Sorry, 13 takes lot.
No, not at this stage.
I mean, it's not at the chronologically mentioned.
Not at this stage. Not at this stage.
But,
Where is your right?
so,
You have no right to address. You will be addressing while we decide on the substantial questions of law.
I think I have felt caveat, so I
Caveat you can oppose the stay prayer, not on the admission.
Admittedly, my lord, they have against concurrent finding. Already Learned Trial Court in the 2000 decided all the title as well as even the.
We have seen that. We have seen that. Your scope is absolutely limited at the
Yes, my
time
lord.
of framing of substantial questions. You see the chronology of section 100. We frame substantive questions. Thereafter, you will get a right of hearing.
Absolutely. My lord, it is my only humble prayer, my lord. Lordship is admitting on this point. For the last 30 years, by dispossessing they are enjoying this land. So my advice is let the lord to admit a LCR call and after receiving LCR, my lord, since they're keeping this patic hearing me.
Okay, we will consider. We'll consider. Yeah. 3 and 4, huh? Any other, huh? Any other उसके बाद 3 and 4 डिलेगा any other substantial question of law जो एक लिखता हूँ हम लोग. This court may frame any other substantial question of law after notice to the parties जो लिखता हूँ. फिर call for the LCR. Let's steps. Sorry, you will be accepting notice for all.
No, 1, 2, 3 and 6.
At this stage, Sri P.K. Decca Learned Counsel submits that he would be accepting notice on behalf of respondent numbers 1,
2, 3 and 6, my lord.
2, 3 and 6.
Yes, and so far for my information, 4 and 5 got expired.
3 and 6 full stop. He has also submitted
1, 2, 3, and 6.
that the respondent numbers
4 and 5.
4 and 5 have passed away in the meantime.
7, 8, 9, 10 is here.
Let extra copies of this memo of appeal along with the enclosures be served upon Sri Decca within 2 days. The Ms. Roy, Learned Counsel assisting the Learned Senior Counsel for the appellant would also take necessary instructions regarding the subsequent steps to be taken on the death of respondent numbers 4 and 5. Full stop. List after 6 along with a report on the receipt of LCR. Okay. Have you gone for execution?
Not, yes, so it's already made a preferred execution proceedings.
Now, has it been started?
Yes,
Yes.
We have not yet received notice. This
You have not received notice.
but they have started it.
Where have you stated? In your stay prayer?
করি না।
We'll consider it whenever you receive notice. We'll leave it open.
Paragraph number 7, we state, we say that opposite party is taking steps to execute the report judge. Because at that point of time, they were taking steps. But in the meantime, it has so happened
No,
that.
it is filed on 6th of June only.
Yes.
Not very long back. Only 4 or 5 days back. Once you receive notice, we'll pass orders. In the IA, like I want, the IA will be considered as and when the need arises, and on receipt of any notice of execution of the impugned judgment and decree.
I pray.
Let the notice, let the LCR come, we'll take a call. 6 weeks we have said.
Apply.
That is why we have not passed any stay order. We are trying to balance the equity.
Yes, Lord, that's it. Okay.
Okay. 13. Okay. Yes, madam, what is this?
Lordship, Lordship, service, Your Honor, service upon resolution number 1 has been completed. But due to deficit stamp duty, Lordship, service upon the number 2A, 2B, and 3 could not be completed. Due to inadvertent mistake, Lordship, that has not been.
Okay, but this is pending since long, madam.
Yes, Lordship, due to bona fide mistake, that has.
Okay, we grant you 2 days time to fulfill the deficit. Okay. Office note dated 7/6/2024 reflects that the deficit postal stamps for the notices upon the response numbers 2A, 2B, and 2C are yet to be deposited. Para, your name, madam?
Miss G. Gayan. Miss G. Gayan.
Ms. G. Gayan, Learned Counsel, appearing on instruction of, who is your senior?
Mr. N. Bharat.
N. Bharali. Praised for, and is granted 2 weeks time, 2 days time, 2 days time to deposit the deficit postal stamps. List after 6 weeks, along with report on service upon the aforesaid respondents. You, Madam Das for? Miss you Das is present for the. Is present for respondent number?
1.
1. Yes, next.
14.
My lord, this appeal has been preferred for enhancement. My lord, my learned friend, my lord, has appeared for respondent number 1, and my lord, respondent number 2, my lord, is the owner come driver. AT card has received, has not appeared. In fact, my lord, in court below, my lord, he was not appeared. My lord.
LCR has not come.
LCR has not come.
Case of which year? 2006.
2014, my lord.
MSC of 2006.
But in fact, my lord, several remainder has been put from
2006, is it easy? It's very easy to criticize, but 2006, will you be able to?
Appeal has been given on 40, 2000. My lord, may I pray one thing, my lord? Subject to.
Now, why do you need the records?
The record should come from.
Now, why do you need? Do you have certified copies of the evidence? What are your grounds for enhancement?
My lord, enhancement, my lord, only my lord award, my lord, money awarded, my lord, only 2,41,000, my lord.
Injury case or death case?
Yes.
Death case.
Yes. And may I pray one thing, my lord? Let the matter be placed before Lukadala, subject to my lord consent of my learned friend. It was my lord.
Yes, Mr. Sakya?
But whether
But what is your claim? Let us first
My lord,
Be perhaps
claim,
satisfied
my
that
lord,
there may be a case for enhancement.
my lord, claim, my lord, only, my lord, ground I have, my lord, here, my lord. Thesis was, my lord, thesis, my lord, was a, my lord, bachelor, my lord. He's a lady, my lord. And at the time of her date, he was 28 years old. And multiplier should come 20. Now, my lord, in the tribunal, my lord, multiplier held on the basis of the claimant, that is not proper. Only 13 was set, my lord.
Okay.
On the basis of the age of claimant.
Who are the claimants?
Claimant is brother, my
Brother. Okay, age of the brother has been taken into consideration,
lord. That is not
not
proper,
of the deceased.
my lord.
Okay, that
But
is one. Okay,
On
then
the
the
other hand, my lord, income of the deceased man was held only 3,000.
okay.
My
Well,
lord,
how much is your income?
my lord, at least, my lord, that could be enhanced, my lord. That,
Income was how much? How much did you claim to
my
have
lord,
to be earning?
I exhibited a certificate, my lord.
Yes.
Certificate, my lord.
What was the deceased doing?
He was the agricultural laborer.
Labor. How
Yeah.
much was the monthly earning?
My lord, monthly earning was, I have 6,000, my lord, per month.
6,000. Proved by whom?
My lord, in fact, my lord, that certificate was
Certificate not proved.
not
Then,
only exhibited, my
but
lord. That
Mr.
certificate was
Mr.
issued from
Saikia,
the circle officer.
we'll consider this a multiplier option.
One thing is the elder brothers are claiming. Was not dependent on the team. So that they are not entitled. Brothers.
Where is your appeal?
But it's not
So, you should have preferred an appeal.
further
If there is a no
enhancement
dependency factor, you should have preferred an appeal.
My lord, only one
If
thing.
you
may-
have
my lord,
accepted that, then we have to go by the correct multiplier.
but
No, where is your appeal? Why should we consider this? You cannot assail the judgment being a respondent in absence of a cross objection.
my lord, may I say one thing? My lord?
We'll finish this. How much difference will it make? By changing the multiplier, will not interfere with the income, only the multiplier part.
Multiplier part, it should come, my lord, separately.
No, how much will be the difference now?
My lord, at least, my lord, 3 lakh.
Have you made the calculation?
My lord,
You should make the calculation, make
after
a rough
some time, my lord, I will make calculation. After
make
10
the calculation. And what is that paragraph of chronicity? Which paragraph?
Chronicity, my lord, as per chronicity, multiplier should come.
Which paragraph?
Chronicity, my lord, time.
You have not brought chronicity. Court has to bring a
I'm not
chronicity
having
for you. Which paragraph?
Chronicity, my lord, as per chronicity, my lord, multiplier.
Paragraph 22.9.
Maybe. Not.
You have chronicity with you.
Not good.
You check chronicity.
My lord,
Bring, I think
my lord, judgment,
22.9.
my lord, Amrit Bhanu Khali, in this judgment, my lord. Supreme
Why
Court.
do you go to you go by the
My
chronicity?
chronicity, my
That is
lord,
a
the
larger
best
bench.
judgment.
Everything has been settled.
Yeah, everything.
You make the calculation and come back after some. But with this, we are going to rise very soon. 3:15, we are going to rise.
let the matter come for hearing of in that case.
Why 2014 matter? What do you gain?
My lord, initially, my lord,
What do you gain? Did you finish your this 10 years old matter, MSCT? Does it look good?
my
Date may be fixed.
Why date fixing? Today is the date. Today is the date. Only on that aspect. On that multiplier part, there is no question of any preparation. That's a settled position. And these are law, not by the legislative. These are law interpretation by the court. It will have retrospective effect. Mr. Mannaf, no assistance from you.
I'm sorry, my lord. I'm not having, my lord, with the chronicity, my lord. Okay.
What multiplier was used?
My lord, As per my lord, Pranay, it is 17.
Now, what was used here?
My lord, used my lord, age of the, my lord,
How much?
my lord, 13, my lord,
13 used.
13 used,
And you are entitled to?
17.
What was his age? Age of the deceased?
Age of the 28 years.
Should be 17. Deceased is was 17 years, 28 years old.
Right.
For 28, is there any dispute regarding Mr. Saikia of that the multiplier is 17?
No, no.
Okay.
That our subsequent they are not entitled for the elder brothers or claim.
My lord, in this regard, my lord, they, my lord, prepared an appeal. Appeal has been remanded back earlier, my lord, remanded back to the tribunal. Tribunal, my lord, directed additional evidence should be, my lord, taken. And accordingly, we examined, my lord, 4 witnesses along with doctor. And next time, my lord, the second.
Okay, tomorrow we'll take it up. Tomorrow. Bring the, make that calculation also.
My lord, I will take.
Mr. Saikia, tomorrow. Paucity of time did not permit the matter to be taken up today. Full stop. Considering that this appeal is for enhancement of an award passed by the motor accident claim tribunals and the claim petition being of the year 2006, comma, a list again tomorrow for further consideration. Tomorrow we'll dispose this of.
Obvious.
Oh, it was here to trouble about it. Huh?
May I? Today is, so my lord, the service completed my healthcare also. Economic, for admission.
You're appearing,
My
Mr.
lord,
Nandi?
yes, I am appealing for the respondent. I pray that I may be allowed to file my affidavit.
Affidavit in CRP, why?
CRP, because this, it relates all are on the basis of the facts.
No,
Really?
we'll not go by the pleadings in CRP. We'll go whatever is there before the, was there before the lower court. If you want, you can file, but that is not necessary. You can make your submission based on the, we'll not go by the pleadings. It's not pleadings here.
If it's of the, because as it is CRP.
All the records are there. We'll go by the correctness of the judgment. Why do you need time? We'll have it for admission.
Admission.
Okay. Heard Sri S. Saikia, Learned Counsel for the petitioner. Full stop. Where is item number? Sri D. Nandi, Learned Counsel has entered appearance on behalf of all the sole respondent. Full stop para. The CRP being of the year 2019. Please for admission hearing after a week.
Right.
When an endeavor would be made to dispose of the same. Is there any stay order?
Yes, my.
Relating to execution.
You're a decree holder,
I am in the, I had a counter claim and counter claim was
decreed.
16.
Oh, how much I see told. Okay.
it will be on 20, my lord.
List after a week. List after a week. On the prayer made on behalf of the petitioner, list after a week.
Until 17.
Yes, you had made a mention in the morning. What is this?
Due to the family emergency, the council is not there.
No, that is okay. Let us see what is there.
family.
No, no, we are not passing any adverse order, madam. Let us see why is it been listed today for orders. Additional affidavit has been filed as Y. Office note dated 31/5/2024 depicts that the additional affidavit has been filed, full stop, on a prayer made on behalf of Sri S.P. Roy, learned counsel for the petitioner, applicant, appellant. List after a week. List after a week. Madam, you are for whom? 1 and 2?
Yes.
Okay. The respondent 1 and 2 are represented by Miss
D.
DDV, learned counsel.
So this has been completed and LCR has been received. It may be posted for hearing.
You are appearing.
Yes, Your Worship, I am appearing for all the, on behalf
Ah.
of the AK Gupta.
Okay. This appeal has been admitted on 8/11/2023 and pursuant to the said direction, comma, the LCR have been LCRS, have been received, full stop, para. The respondents have also entered appearance to learned counsel, full stop, para. List this appeal for hearing in its turn.
Obliged, Lord.
I may be excused, my lord. I could not file affidavit, reply affidavit, so my lord, another 2 weeks time may be granted. The copy they have served me, it was misplaced, my lord. I have applied for certificate.
He'll give another copy.
My lord,
I am on behalf of respondent number 3 to 7, my lord. I want some more time for filing it.
Then who has filed affidavit?
And I one and
Okay, now you have copies or not, Mr.
I don't have, my lord. I applied for certificate copy.
No, no, you give a
They
copy,
may be kind enough to give me a copy.
but the photocopy
Oh,
charge
yes,
is
yes. I don't pay the cost.
at the rate of what?
As your worship, please.
Not at the, it will be a premium. Because you have lost the copy.
I'll offer a my lord, cup of tea. With some snacks.
Agreed?
Aye.
Okay.
I'm obliged.
Sri A.K. Purkast, learned counsel for the petitioner, as well as, Sri, your name?
AK Azad.
A.K. Azad, learned counsel for the respondent number 3 to 7, pray for and are granted 3 weeks' time to file affidavits in this case.
Obliged. Obliged.
Last. This is the last matter, yes.
It will take some time.
So they have filed an application for adducing additional evidence. So there is no ground expressed. on
41/27.
Order 41 Rule 27. Nothing is written why it could not be produced or why it is being brought now.
No,
So
I think
that
your
is-
application has come up.
That is,
Anyway, Lordship,
that is one
that will be
application
taken
and
up at the time of hearing, I think.
Which
But
is your, for under 41/27?
1 minute.
that is 1752 of 2024.
1752 has also come, yes.
Yes, and my IA is for releasing certain amount of the award,
Okay.
which they have deposited with the registry.
Award in a motor accident claims tribunal.
Yes.
Regarding what, injury or death?
Death.
Death, how, so will allow this?
No, no, Lordship. That we have filed our objection to that, Lordship. That's why I said it will need some hearing. And Lordship, thing is, the case can be in fact finally disposed of also. Tomorrow also, Lordship can. We will need some, because the service is complete
No,
and.
no, why are you objecting to the release?
So, Lordship, because of this policy, in the policy, premium was paid for the passengers. And Lordship, in the claim petition as well as in the judgment, it is mentioned that they are gratuitous passengers. Claimants themselves admitted that they were gratuitous passengers. If that be so, Lordship, then the insurance company won't be liable. That's why we have filed the appeal.
But at least somebody will be liable.
Somebody will be liable.
Where is the owner?
Owner, Lordship, owner
Owner is not there.
owner is served. Lordship.
Party or not?
The appeal by them, my lord. must have
Appeal
been-
by us.
What was the finding on gratuitous passenger?
No, my lord,
No,
there are- it was not
before-
gone into because of the fact that certain judgments of Honorable Supreme Court has been referred. And where it has been said that if it is a comprehensive policy, my lord, regardless of the conditions, my lord, they will be liable.
It was a
No, but the
comprehensive.
most
policy.
comprehensive policy
vital judgment
and-
of the apex court was not taken into consideration.
And my
That's
lord,
what-
this is also the same point reiterated by this Honorable Court. Your lordship can take it up tomorrow, my lord, if it is
Yes,
agreeable.
I'm
to you.
agreeable.
Tomorrow we have got many matters, even last matter we have. Let it be next week, next Thursday for final
Yes,
consideration. Final consideration.
Yes.
Next Thursday.
So take for, no, in this matter, are you there?
Well, in that case, can it be on?
Then I will not hear you.
In that case, can it be on 25th, my lord?
No issue with me.
25th, okay, can be.
Next week, my lord, some difficult.
Yeah. Okay, paucity of time did not permit the matter to be taken up
25th is
today.
next.
Para, as requested, list on 25th. Okay, rest matters, dates will be given.
I'll object.
Mr. Sheikh, please, make. Good to. What correction?
Lordship, Lordship, kindly have a look at page 14,
1-4.
Lordship. Petitioner number 4,
Yes, please.
his name is inadvertently, wherein this writ petition was Shahidul Islam,
Hmm.
Shahidul Alam, Lordship. And address also, he is a resident of Berenga, and in respect of petitioner number 7, it is Abdul Hussain, estate of Lordship Abul Hussain Majumdar, and his father's name Ilyas Ali Majumdar is name. I have stated in para 2 page, Lordship.
Judgment regarding what?
Lordship, it was the police, Lordship, Assam Industrial Security Force appointment was there under citizen.
Who was the counsel?
I was
You are the counsel.
for the petitioner.
No, if there is not a error in the judgment, you have pleaded wrong facts.
Lordship, that
It was not corrected during when the writ petition was alive. Difficult. Now we do not know the identity. You are changing the identities.
Hmm.
Father's name changes, name changes,
father's name only, title was not there.
whatever. You did not make any
But in
application
the
for.
writ petition, there the annexed Lordship.
It's not that easy. Some rights have accrued upon certain persons who were named in the order. Now, if you are to change in the names along with father's name, it's not a mere typographical error. While extracting from the writ petition, you had stated wrong facts. You did not make any effort to correct these writ petitions are pending for more than 2 years. All writ petitions of 2022 decided in May 2024. We'll consider this not like this. Did the back one. Immediately no lagi. Okay.
34, there is any stay order till?
Okay, 34, interim order. Is it till today?
Yes.
Okay.
May I please, your lord? Lordship,
I lost my son in the year 2015. And the award was passed on 2018. And till 2018, till today, the stay application is pending, and I have not received a single penny, Your Lordship. Item 23.
Get a date, we'll have it.
Obliged.